Good afternoon. I'm Larry Poneroff, and it's my pleasure to welcome you to the 12th annual commemoration of Constitution Day at Arizona Law. I know there's a right of free assembly somewhere in the Constitution, and we want to thank you all, so many of you, for assembling here, right, freely. Well, some of the students, actually, but that's a different story. And I want to thank our distinguished panel. I know they all worked very hard preparing for the presentations today, and I really think you're going to find it an interesting and stimulating presentation and discussion. Once again this year, Constitution Day at Arizona Law was sponsored and organized through our Rehnquist Center, which of course was established several years ago to honor the legacy of the former Chief Justice by providing public understanding and education with respect to key critical themes of the constitutional structure of our government. Issues like separation of power and federalism and judicial independence. Over the years, like this program, the Rehnquist Center has done some extraordinary programming, which has frankly brought great prestige to the College of Law and the university, and almost of equal importance, has served an incredible public service both in our community and across the nation. Now, in a moment, I'm going to turn things over to Sally Ryder, who, in addition to being an alumna of this institution, is the director of the Rehnquist Center, and she's going to introduce our panel. Before I do, however, I did want to, one, apologize to all of you and to the panel, not just for having my back to them the entire time, but to all of you for the fact that as soon as I turn it over to Sally, I will be leaving. And I wanted you to know the reason why, so you didn't misunderstand the gesture. Now, one possible reason, of course, is that deans are essentially ornaments, and once it gets down to substance, I'm largely superfluous. But today I have a better reason, and that is I am actually in the middle, I'm taking a break, of a conference call of a subcommittee of the Advisory Committee on Bankruptcy Rules on which I serve. And in view of the fact that Congress's power to promulgate uniform laws on the subject of bankruptcy derives directly from Article 1, Section 8, Clause 4 of the United States Constitution, I cannot imagine a better way for me to be spending Constitution Day. So, once again, thank you all for joining us. I think you're in for a treat. And now, here's Sally.
I also want to thank the Marshall Foundation and the Wings Like Eagle Foundation, whose generosity helps support public programs like this. And now I'm going to introduce the panelists. On my far right is Judge Neil Wake, who sits on the District Court for the District of Arizona in Phoenix. Before taking his seat on the bench in 2004, he was in private practice in Arizona and was both an election law and an appellate litigation specialist. Judge Wake has been a frequent contributor to our programs, and I want to thank him for his support of the center and for being here today. Next to Judge Wake is Toni MASSARO, who is Regents Professor, Milton O. Riepe Chair in Constitutional Law, and the Dean Emerita of the James E. Rogers College of Law. She was the driving force behind the creation of the Rehnquist Center and sits on the advisory board. Thank you very much, Toni. Next to Dean MASSARO is Maureen Mahoney, who's a member of the appellate practice in Latham and Watkins, Washington, D.C. office and former United States Deputy Solicitor General. She's handled a broad range of constitutional appellate litigation in the Supreme Court and other courts throughout the country, including, I think, 21 arguments before the Supreme Court. Before I ever saw Ms. Mahoney argue before the Supreme Court, I heard this story that I thought was an apocryphal story, and it was that during her very first argument before the court, she was so incredibly good that the justices during the argument were passing notes back and forth, commenting on what a brilliant job she was doing. And then I saw Maureen argue for the first time, and I realized it had to be true because she's that good. Maureen is also a member of the Rehnquist Center Board, and she traveled from Nantucket to get here, which was a long way for her to come. I appreciate your support of the center and being here today. Thank you.
Just wanted some warmth.
And last but not least, David Marcus is an associate professor of law here at the College of Law. He graduated from Yale Law School, clerked for Judge Willie Fletcher on the Ninth Circuit Court of Appeals in San Francisco. He is also a frequent presenter at our Constitution Day program, and I appreciate especially his willingness to summarize the cases each year. And that's especially true today. I want to thank Professor Marcus and all of the panelists because the opinions today run over 500 pages. And they're dense. It's not light reading. So thank you all. Professor Marcus is going to start us off, as he usually does, with what I anticipate is going to be a brilliant, funny, and left-leaning description to set the stage for the panel's discussion. And then he will summarize each case, and after each time he summarizes a case, the panel will discuss the case, and if we have time, we'll take questions from the audience. Professor Marcus.
You'll note that the qualifications of the panelists dramatically fell off when we got to the end. Thank you very much to Sally Ryder for organizing today's exercises, and thank you very much to the members of the panel, particularly to Ms. Mahoney and to Judge Wake, our outside visitors who are great friends of the school. It's really an honor to have them here with us today. I want to start with 3 disclaimers. First, I'm not a constitutional law scholar. I'm a proceduralist, and only 2 types of people are willing to spend their lives researching civil procedure, either overworked deans or simple-minded mouth breathers. I'm not an overworked dean, so you can draw your own conclusion. I'll do my best to give a summary, to summarize these opinions as accurately as I can, but I will anticipate that our panelists will have to clean up the mess that I make. Second, I know that some of you think about law professors the way that Woody Allen described New Yorkers in his great movie Annie Hall, that we're all left-wing communist Jewish homosexual pornographers. I think of us that way, and I am a law professor. So I'll say at the outset that I don't have any pretenses towards objectivity. And then third, I talk quickly. So I'll take a few minutes to give an introduction to the term before we get to the cases. As in years past, I'll use this time to indulge one of my obsessions. To introduce a Supreme Court term with some claim about an underlying theme or overarching message is a difficult task. The Court does not begin each term with some goal of writing a novel or a jurisprudential treatise that has some underlying consistency to it. Rarely do the Court's decisions follow some simplistic pattern that lends itself to facile characterization. The supposedly pro-corporate, arch-conservative Roberts Court ended the term with 6 straight consecutive pro-plaintiff decisions in civil cases. Rather than try to articulate some theme for this past term, I'd like to reflect a little bit about our current constitutional moment. I cannot recall a time when the Constitution seemed as ever-present in our political discourse as it is today. Last summer, in the heated debates over President Obama's health care plan, opponents were fond of invoking the 10th Amendment as a purported bulwark against what they saw to be an overreaching, a power grab by the federal government. On the other side of the political spectrum, many liberals a few years ago expressed a lot of interest in Article I, Section 8, which gave Congress the power to declare war, and used this Article I, Section 8 as an argument that the Bush administration's prosecution of hostilities in Iraq and Afghanistan was illegitimate. I could easily multiply these examples. It's tempting to wield these constitutional arguments in political debate because they are trumps. If I disagree with you as a political matter, I may find your position abhorrent and disgusting, but it's not unlawful, it's not out of bounds. But when I say that your political opinion is unconstitutional, I am saying it is indeed out of bounds and is legally unacceptable. Law is something apart from and superior to politics, or so the understanding goes, and it should beat it every time. There's a deep irony in this use of law as a trump in political debate. Once I say that your political opinion is unconstitutional and therefore out of bounds, I make our political differences irreconcilable. When we disagree simply as a political matter, there's always the possibility that you might convince me. But once I say that your opinion is unconstitutional, I cannot admit that I would ever buy into it unless I were to accept a lawless society. Our politics become more polarized, not less, as we introduce law into the debate, or at least a conception of law, a law as apart from and superior to politics. I think extreme polarization pretty well describes our current political atmosphere, and I think that mindless descriptions of law and the role of the judge by people who know better should shoulder some blame for how this misuse of constitutional text has further entrenched our political divisions. The insipid analogy Chief Justice Roberts drew between a judge and an umpire, and an analogy that the subsequent 3 Supreme Court nominees parroted at their confirmation hearings, and an analogy crucial to the maintenance of the law-politics divide, has in particular proven destructive. But isn't the alternative to a rigid law-politics divide cynicism? The opposite is true, I think. When you accept that there are no legal certainties and that texts take on new meaning depending on changing political, social, and economic climates, then you understand, to quote Justice Holmes, that certainty is generally an illusion and repose is not the destiny of man. If you don't treat the Constitution as apart from the living political moment, if you aren't willing to accept that the way we should resolve disputes is by violence, then you have to put faith in the process of dispute resolution we've given to us, and the people to whom we entrust that process, chiefly judges, that they will work together in good faith, often disagreeing, but always accepting legitimate disagreement as acceptable toward a better constitutional future. As David Souter recently said in a speech that I urge you all to read and study carefully, a speech he gave last May at the Harvard commencement. As he said in a speech that is an eloquent antidote to the ball and strikes absurdity of several years ago, in an indeterminate world I cannot control, it is still possible to live fully in the trust that a way will be found leading through an uncertain future. If we understood that there is no impermeable boundary between law and politics, and that constitutional law is in many important respects nothing more than politics, we could have our debates over the burning issues of the day, even argue over our side's constitutionality, without the Constitution becoming a wedge that drives us further apart. Each of the 4 cases we'll discuss today illustrates in a different way how law is indeed inseparable from politics. There are sort of surface-level ways to make this point. One is that each decision is a 5-4 decision with the split along ideological lines. One of the decisions, Citizen United, is indeed a spur to cynicism, because I cannot imagine a more brazenly political decision. But another, I also couldn't imagine a more thoughtful, inspired set of opinions than what the court produced in the McDonald versus Chicago case. Decisions that, although they reflect the justices' ideological divisions, are also so richly and intelligently argued that they make me confident that reasoned elaboration and respect for disagreement are indeed possible despite our overheated political climate. I'd happily prefer an understanding of law as on a continuum with politics if it commits us to the kind of reasoned elaboration that's evidenced in McDonald, over the smug certainty of law as autonomous from politics if it means irreducible divisions. With that moralizing and preaching over, I'll turn to the Christian Legal Society case. Boy, I forget the name of the case right now. We're in big trouble. Christian Legal Society versus Martinez is the paradigm of what I would call a hard case. A group of students at the Hastings College of Law, which as you probably know is part of the University of California system, asked the college to recognize their chapter of the Christian Legal Society as an officially registered student organization. Citing its non-discrimination policy, Hastings refused on grounds that the CLS required its members and officers to sign a statement of faith that disavowed homosexual conduct. CLS challenged this refusal on First Amendment grounds. Given how hard this case is, it's ridiculous that I, someone who can barely spell the First Amendment, should introduce it when we have on our panel one of the lawyers who represented Hastings before the Supreme Court. My august colleague, Dean Massaro, has come up with 6 frames which I think we can use to understand the case. I'll let her elaborate on these, but let me suggest one which I'm sure is overly simplified but might be of use. On one hand, I think of this case as a clash of rights. On one hand, gay, lesbian, bisexual, and transgendered students would argue that they have a right to attend a public institution of higher education that does not sanction discrimination based on sexual orientation. On the other, members of a faith-based organization whose religious tenets frown on homosexual conduct would argue that they have a right to associate only with those who share their beliefs and that the institution cannot deny them this right. How do we navigate between this constitutional Scylla and Charybdis and get the answer right? Having to deal with these sorts of issues is a reason why I believe that the willingness to serve as dean of a law school is rebuttable evidence that someone is suffering from incipient mental insanity. Here are the facts.
You got better. I'm recovered.
I stress rebuttable presumption, a rebuttable presumption. That's not to say that there aren't other pieces of evidence that strengthen the presumption in this instance. Here are the facts. To quote from its mission statement, the Christian Legal Society is a nationwide organization that seeks to proclaim, love, and serve Jesus Christ through the study and practice of law. CLS has chapters across the country, including one here in Tucson for practicing lawyers and a chapter at the University of Arizona Law School for students. Student CLS chapters permit anyone at all to come to meetings, but to be an officer or voting member, according to its bylaws, someone must conduct their life according to established tenets. These include the principle that there shall be no sexual conduct outside of marriage, with marriage defined as that between a man and a woman, a principle that necessarily excludes LGBT members and officers. In 2004, a group of students at Hastings applied to their college to have their chapter of the CLS recognized as a registered student organization, or an RSO. RSOs at Hastings get some modest benefits. They can use official law school channels to communicate with students, such as listservs and the like. They can publicize events in law school newsletters. They can use Hastings organization email addresses. They get some modest funding. But most importantly, I think, they get the Hastings imprimatur on their official doings. Now, the problem is that Hastings requires all RSOs to abide by a non-discrimination policy, which provides that organizations may not discriminate unlawfully on the basis of a number of enumerated categories, including sexual orientation. As Hastings insisted during litigation, this is an all-comers policy, a policy that requires student organizations to allow any student to participate fully and assume leadership positions regardless of her conduct or beliefs. The administration refused to recognize the CLS as an RSO. I'm starting to sound like my brother-in-law, the colonel in the U.S. Air Force, who refers to my sister-in-law as W-A-M-O-M-C, wife and mother of my children. CLS could meet in law school rooms, but Hastings would do nothing to support the organization and thus denied it its imprimatur. In response, CLS sued, alleging that the refusal to recognize a group as an RSO violated its First Amendment rights. The District Court and Ninth Circuit agreed with Hastings, and the Supreme Court granted cert. I should say that this issue has come up at other schools. CLS has sued the Arizona State, Ohio State, and the Southern Illinois University law schools over similar refusals. It just so happens that the Hastings case went to the Supreme Court. I'm not really sure why. It might have something to do with the fact that the Ninth Circuit is an irresistible target for the justices, a target that has given it the moniker, in words of one of my former bosses, is the Ninth Circuit reverse-o-matic. As I see it, there are two key issues in this case, one factual issue and one legal. The factual issue is the following. Was Hastings' policy an all-comers policy or a non-discrimination policy? An all-comers policy would require student organizations to accept anyone regardless of a person's belief. So the Hastings Democratic Law Student Society, for example, would have to permit Republican students to join and actually become officers and perhaps even the president. A non-discrimination policy would prohibit student organizations from discriminating against individuals on certain enumerated grounds having to do with race, religion, and sexual orientation, but otherwise permit groups to discriminate based on belief. So the Hastings Democratic Law Students Society, for example, could refuse to permit a Republican student to become a member or an officer. This is an important question because it goes as a factual question because it arguably goes to the issue of viewpoint neutrality. The legal question is, was Hastings' policy reasonable and viewpoint neutral? Whether the policy was an all-comers or non-discrimination policy, the factual question is important to resolving this legal one. Justice Ginsburg wrote the majority opinion on behalf of herself and the four other godless communists, Stevens, Breyer, Sotomayor, and Kennedy, and Justice Alito wrote the dissent for himself and the three other religious fanatics, Justices Roberts, Scalia, and Thomas. As to the first question, the factual question of what type of policy Hastings applied, Ginsburg found this to be an easy case. As written, the policy at issue was a non-discrimination policy, but as applied, she said, it was an all-comers policy. And she stressed that Hastings had always applied as an all-comers policy, something that the parties stipulated to at the summary judgment stage, that they stipulated that it was an all-comers policy. Now, Justice Alito strenuously disagreed with this characterization. He said, well, yes, it's true that by 2005, Hastings, as for its litigation position, was describing its policy as an all-comers policy, that before then it had been administered as a non-discrimination policy that selected out religious organizations but did not require other organizations that formed around certain beliefs to allow everybody to participate. Now, Justice Alito's argument on this front angered Justice Ginsburg a great deal, essentially mostly because Justice Alito seemed to insult the veracity of a distinguished civil procedure professor. And there's one thing that we all know, and that is civil procedure professors do not lie. They are the core of our moral center in this otherwise torn country. Because of this, Ginsburg claims Alito engages in make-believe, describes his argument as desperate and warped analysis, and criticizes him for impugning the veracity of a distinguished legal scholar and well-respected school administrator. Harsh words from Justice Ginsburg. Okay, assuming that it was indeed an all-comers policy, did it violate the CLS's First Amendment rights? Hastings' RSO system is what we call a limited public forum. Hastings is a public law school, but the use of its public spaces, or rather the channels it provides for communication, like those that the RSOs can exploit, can be limited. The fact that Hastings is public doesn't mean, for example, that the San Francisco chapter of Jews for Jesus can demand to use its classrooms. More to the point, the fact that Hastings is public doesn't mean that Jews for Jesus can insist that they should be able to table at student orientation events and the like. Hastings can restrict access to its limited public fora if the restriction is reasonable and viewpoint neutral. To an extent, a limited public fora is a benefit or subsidy that Hastings provides, and it can condition access to the subsidy on with certain restrictions. The standard for reviewing a policy that restricts access to a limited public forum is the policy reasonable, and is the restriction viewpoint neutral? Justice Ginsburg has little difficulty determining that the policy is reasonable. Law schools should have some flexibility in determining the best educational environments for its students. Law schools can take steps to ensure that they won't subsidize, public law schools, they won't subsidize conduct such as discrimination against people based on sexual orientation that law schools don't want to sanction. Justice Ginsburg also has little difficulty finding that the all-comers policy is viewpoint neutral. It draws no distinction between groups based on message or perspective, to the extent that it requires CLS members to associate with those whom they find morally abhorrent. This is just an incidental effect of an otherwise neutral policy. You have to take everybody in your organization. From the perspective of someone such as I, who knows about as much about the First Amendment as Sarah Palin, there's the homosexual Jewish law professor pornographer coming in, not necessarily in that order. This is where the opinion starts to smack of some legal hocus pocus, at least to me. Justice Ginsburg insists that Hastings' policy permits the CLS to broadcast any anti-gay message it wants. Hastings could not have a policy that prohibited that restricted groups' beliefs. This would be an impermissible restriction on speech. But Hastings can require the CLS to admit as members any gay student who wants to join. CLS, I would imagine, argue that conduct is a form of expressing beliefs, and that the act of association is itself the expression of a belief. Justice Ginsburg, it seems to me, denies the idea that we broadcast our beliefs through our associations, something I have a hard time agreeing with. I think the decision was correctly decided, but if I were writing from scratch without all the First Amendment hand-me-downs the court has to deal with, I'd probably more frankly acknowledge the clash of rights in this case and try to explain as a pragmatic matter why the balance favors Hastings. I think there's something a little bit formalistic in Justice Ginsburg's distinction between belief and conduct. But now it's time to let my co-panelists set the record straight and explain why I'm wrong.
Thank you, Professor Marcus. Ms. Mahoney, as having represented Hastings in the Supreme Court, as Professor Marcus pointed out, there was quite a difference in interpreting the record between the majority and the dissenting opinions. And the Ninth Circuit opinion, which was the opinion that went to the Supreme Court, was only about 2 sentences long. Did that make it more or less difficult to defend the Ninth Circuit's judgment?
Sally, it wasn't just about 2 sentences long. It was 2 sentences long. Did it make it more or less difficult? I think that it probably made it a bit more difficult because I think it really fueled the dissent's sense that they needed to have a full record on this very difficult issue. Because the Ninth Circuit had treated the issues summarily, I think that really caused the dissenters to feel that there had to be a full airing of what they viewed to be the salient history here. And I'm not sure that they would have done that if there had been a complete opinion from the Ninth Circuit. On the other hand, The Ninth Circuit's 2 sentences got it exactly right. What they said is there is a stipulation here that this is an all-comers policy, and that means it's viewpoint neutral and it's reasonable, and therefore it's constitutional. And so from that perspective, you know, that makes it easier to defend because you weren't having to run from the rationale. On the issue of, you know, this debate between the majority and the dissent about what the record really was, I would just like to read the stipulation quickly because I can't help it, but I'm an advocate. You know, this idea that Hastings' policy wasn't really that the Democratic caucus would be required to admit, you know, those who have Republican beliefs. The CLS actually stipulated to the following: Hastings requires that RSOs allow any student to join regardless of status or beliefs. Thus, for example, the Hastings Democratic Caucus cannot bar students holding Republican political beliefs from becoming members or seeking leadership positions. That's in the stipulation. So I think it was quite fair for the majority to say, this is how the case comes to us. What CLS is asking for is prospective relief, an injunction against enforcing a policy that they have stipulated would require a Republican organization to accept Democrats and vice versa. And so we find on the basis of that record that this is a viewpoint neutral policy. So I think, you know, the majority definitely had the right view of what the factual background was.
What's the significance of the case, do you think?
Well, I think it's significant, certainly from Hastings' perspective. This is their policy, and it means that their policy can be enforced going forward. That they do not have to recognize a student group that wants to exclude others on the basis of any status or belief, whether that's because the students are gay or whatever else it might be, their political beliefs, or whether they you know, are Nazi supremacists, or, you know, whatever it might be. They don't want to have to draw those lines, and so they want to have an all-comers policy. That means for other law schools and colleges around the country, they now, I think, have a green light to use a similar policy if that furthers their own interests. They don't need to, but they can. I think that it's clear, though, that one of the issues that's left open is that for those schools who want to have a different policy, a policy that says, well, we would like for some groups to be able to exclude on the basis of their political beliefs, but we don't want to allow exclusion based upon, let's say, whether a student is gay, a more classic, you know, anti-discrimination policy protecting certain groups and certain status. That question has been left open, and so we'll have to see what happens, you know, in future litigation if schools decide that that's the policy they want. Fair amount of deference to deference to educators in this setting, though, and so I think there's a lot of good things for schools to hang their hat on in the opinion, but it's certainly an open question.
Mm-hmm. Dean Massaro?
The only thing I'm worried about, it's not inconsistent at all with what Maureen has said, but I think what we need to look to the possibility of is a state-level trumping move, that the state could, in the wake of this, if someone lobbies them, say, because Ginsburg was careful to say that the policy was permissible but not constitutionally required. And so it is conceivable that a state legislature would pass legislation prohibiting public institutions within its jurisdiction from adopting rules like this. In other words, prohibiting student organizations or schools from demanding that student organizations have such a non-discrimination policy. And we're seeing a lot of this. I see a number of members of the Office of General Counsel here, and I think they're well familiar with that dialogue that goes on between the legislature, lobbyists, and outcomes of specific Supreme Court cases. So I think that's something to watch. And I don't think that it's possible to figure out what the policy is written, what the court would have done with it. Ginsburg really doesn't address it. And so those of you who have policies, and ours is somewhat like that, that does distinguish on the basis of characteristics rather than an all-comers policy, I don't think it's out of the realm of reason that it could prevail on a constitutional challenge, but I think it's more vulnerable after this case. I also agree with Maureen why it's a tough case. I mean, this case is a con law teacher's dream. I have put it on the exam for 10 years. I'll put it on this year. It doesn't matter how many times. I tell them it's going to be on the exam because there are so many vectors that come into it. On the one hand, you look at it as a funding case. And if it's a funding case, most of the case law suggests, and it would be rather nutty for government not to have substantial discretion, not equal, not neutral, but specific ends it wants to advance through its funds, it's allowed to put those conditions on its money. So they did a great job of characterizing the case, putting it in the frame of a funding case, and then it should be all done but the shouting. I mean, I think that the overwhelming evidence points in the direction of Hastings having that sort of discretion. When you add a forum feature to it, though, the public forum, limited forum, non-public forum, not a forum at all. I won't bore you with the details or try to trouble the limited intelligence of Dave with those kinds of distinctions. But it's a tough and mostly, I think, ultimately illusory distinction among those categories. I think that Thurgood Marshall was right, that it ought to be broken down into more of a factored analysis of is the speech compatible with what government is trying to do in the setting that is more bounded than the street corner. And so those were the big framing moments that controlled the lawyers as well they should. Last thing I'll say is I actually think there's a subterranean aspect to this, and that's what the paper I've done is about. I think that Maureen hinted at this at the end too in saying it's substantially deferential to the officials on the ground. And I think rightly so. Officials on the ground know that even if a student organization engages in speech under the umbrella of the school, that the state action doctrine might not attribute their speech to the school as a legal matter because the state action doctrine has shrunk so since the 70s. The school knows that they are held to a standard that is conflicting in and of itself, and that people will assume that the imprimatur of the school is relevant. You know, the school flag flaps over it just like the state flag and U.S. flag flapped over the building that housed the coffee shop that discriminated on the basis of race. These students wanted access to the official imprimatur. They had access in other ways, but they wanted to belong. And the request for belonging makes the case hard. It becomes hard to deny full belonging. But the request for belonging is to something that itself needs to stand for something else. And it is, I think, just a repetition of the balance between standing for equality and standing for full First Amendment neutrality and marketplace of ideas. And we'll never completely be satisfied we've gotten that balance right. And I think they understood that Hastings Law School had a real dilemma on its hands once, not the students, but once the national organization arrived. And that's another, I think, hidden part of this, is that in a lot of cases it was not the student chapters that brought this thing up. It was and Maureen may know more about it than I.
I would just say that in the record itself, it shows that before the litigation was brought, CLS had a gay member of the organization, and when asked in deposition about how that worked, the representative said it was a joy to have her as a member of our organization. So it leaves you wondering, what is fueling this litigation?
It's not unlike, and this doesn't come in right, left, center stripe, but national attempts to, the Connerly Amendment is a nationally orchestrated attempt to change the law state by state. And CLS, I think, wants its brand, its imprimatur, to imply certain things, and they say these are our rules, and one should obey our rules. But the students themselves, it wasn't, I think, sufficiently organic that the students' deviation from some of those rules, I think it may have been a bad move on the part of CLS, with all due respect, to say that to their students. But at least they've said it very clearly now, and the students will decide for themselves what they think that does or doesn't mean.
Thank you. Judge Wade?
Oh, I have some comments that perhaps touch more on the lawyering aspects of this case, which leap out of this to me. First is the stipulation of facts that the dissent simply attempted to disregard. And as a lawyer and as a trial judge, this is dazzling. Now, perhaps they were let into it because the law school had diverse defenses of its policy, but there it was, a stipulation of facts as clear as day. And by the way, the second thing is the Ninth Circuit's two-sentence affirmance. Now, let me tell you, they were not picking on CLS because the Ninth Circuit routinely has memorandum decisions of that brevity or not much longer because they dispose of 6,000 or 7,000 cases a year, and if there is what appears to be a sword to cut the Gordian knot, they're not going to unravel the Gordian knot. So that's what they saw here, and I know they've done it to me. I'm happy to be affirmed on a one-paragraph decision, and one time they reversed a 35-page opinion I wrote just citing a decision that no one had cited to me, and they were right. So that was the end of my decision. But so they weren't picking on CLS when they thought there was a clear dispositive basis to decide the case. This is an interesting case because of the tone of both the majority and the dissenting opinion. The majority opinion has perhaps a clinical disdain for the dissent, and the dissent has an unclinical disdain for the majority. I'm going to offer a little bit of a thought as to what may be going on here. The Christian Legal Society brought a number of these cases around the country, and they brought one against the Arizona State University. I was the assigned judge in that case. And fortunately for me, the case settled a couple days before trial, so I didn't have to decide the case, although it did rear its head later on a motion for award of attorney's fees claiming that the settlement was really a victory for CLS. I'm going to offer an analysis that was presented in that case. What the university did, and I haven't checked this, but I assume that since this was the Board of Regents, this is probably the policy at this university and Northern Arizona University as well, not just Arizona State. But in any event, in that case, the university had a non-discrimination policy virtually identical to the Hastings. It had never been a source of any conflict or decision from anyone. The national CLS approached the Arizona State chapter and asked them to get involved in litigation. And so the way they did that was, and they voted to do that, they wrote a letter to the administration declining to apply for certification as a student organization because they couldn't sign off on the non-discrimination policy. The university then rescinded the non-discrimination policy. The lawyers for CLS then wrote another letter saying we're still not going to apply because we have to abide by the Student Code of Conduct, and they thought this was implicit in the Student Code of Conduct. They were clearly attempting to set up litigation, so they finally filed a lawsuit not having applied for membership after having written letters saying we're not applying because you're discriminating against us for these reasons. That's how it came to me. The case was settled with the university making some changes. First of all, they agreed that religiously based student organizations could exclude members for non-adherence to the religion which was the source of the common interest, provided that they did not violate other non-discrimination policies, including discrimination against homosexuals. But they agreed that CLS's general criterion of membership that one disapprove of sexual conduct outside of traditional marriage would not be a violation of that anti-discrimination policy. So that's how the case settled. Now, I believe that's probably still the policy in all of our state universities. The argument for that policy was that with respect to the exclusivity of the exclusion on the basis of religion, that where the common interest of the organization is a religion, that non-adherence to that religion is not in any way invidious to the person who's excluded. It's not a mark of a program, it's just a lack of interest. This, of course, it can be viewed as a matter of degree, but as a matter of degree, there's, I think, some substance to that. And with respect to the now approved policy of requiring adherence to the disapprobation of sexual conduct outside of traditional marriage, although this plainly has a disparate impact on homosexuals, the argument is that that disparate impact is a result of all kinds of classifications, and it lacks the particular sting of a focused exclusion. That was the analysis, and that is pretty much the way it works in our universities now. As to the significance of this case, other than legislatures or other bodies changing the actions of universities, I'm wondering whether there's going to be much further litigation, because at least for now the Supreme Court has given a safe harbor for universities to do the all-comers policy, and our universities are even more generous to the exclusionary policies of student organizations. And the reality, and Justice Ginsburg discusses this in her opinion, is that student self-selection of interest is likely to trump neutrality requirements, that students will participate in the things that they're interested in. It's not very likely that there will be obstructionist participation in other groups. The last thought I want to offer is, it's great talking here with, there are a lot of lawyers and judges here, but it's especially great to be talking to all of the students here. And I want to offer some comments about just pure lawyering. The first is the point I made about the stipulation of facts. And the moral of that story is you need to have your case figured out. You can't just evolve in an ad hoc way in response to things. You have to have a grand theory, and you have to understand your weaknesses. You have to understand what you can give up, what your objectives are, and it looks like they didn't do that in this case. Now it did, and it reached up to bite them when they got to the Supreme Court. That is, reached up to bite CLS. The other thing that leaps out of this, both partly from the Hastings case and other cases that I was watching the Hastings case as I was presiding over mine, and I read Judge White's decision when it came down and Judge Kaczynski's affirmance. But one has to ask a question of what were the roles of the lawyers and what were the roles of the clients in this litigation? Because there had been no problem at Arizona State University with their CLS group. And they were approached by lawyers, what they call the out-of-town lawyers, I guess. And they agreed to participate in this. And there are consequences which appeared in the record that I had to examine later of great conflict and difficulty in the ASU organization. Students left, not so much out of anger as hurt, or maybe out of anger. The other students left and formed other organizations, and one has to wonder, if you're a lawyer asking people to undertake litigation, what you tell them, and whether they advise them of the consequences of different courses of action. So when you all get out there, I trust that you will all remember that everything you do is within the bounds of the law and ethics and professionalism and courtesy, but subject to that, the clients come first.
Thank you very much. That's a very good point to end on, I think. Unless you have one more minute, give you some rebuttal time, or you can start the next case.
I'm happy that doesn't seem to be that much to rebut, although I'm sure there are plenty of things that the panelists were kind enough not to say. Just to very quickly follow up, because I think it dovetails nicely into the rest of the opinions that we'll discuss this afternoon. This theme that, particularly in Judge Wake's and Ms. Mahoney's comments about the relationship between the CLS organization at Hastings and the national organization, and who was fueling what and the like. Sort of taking a very bird's eye view, this case and the others reflect a really interesting inversion of the rhetoric about constitutional litigation and pursuing political change through litigation that has been very much in the public discourse since the Warren Court days. And now I think it's very difficult to maintain that public interest litigation is the exclusive preserve of the left as they continue to lose out in the political theater and have to pursue their desired changes through litigation. As the court, at least by its perception, tilts to the right, I think this kind of social change litigation is more and more something that's open to everyone. It's more and more an ecumenical practice. And I think that poses very difficult problems for a lot of the rhetoric about originalism and judicial restraint that evolved as a critique to the Warren Court, and we can see that arising in some of the other opinions.
It's a great segue into the next case, I think.
The next case this afternoon is McDonald versus Chicago. 2 years ago, in District of Columbia versus Heller, the Supreme Court held that the Second Amendment guarantees an individual right to bear arms. It struck down a Washington, D.C. statute that prohibited the possession of handguns within city limits. In so doing, the court aroused a long-dormant amendment from its lengthy slumber. Chicago and one of its suburbs, Oak Park, had handgun bans that were virtually indistinguishable from the District of Columbia's. The same lawyer who won the Heller suit sued to void the Chicago ban. To someone unlettered in American constitutional law, McDonald versus Chicago would seem an easy case. Chicago's ban was the same as the District of Columbia's. The District of Columbia's violated the Second Amendment, hence Chicago's violated the Second Amendment as well. But this appealingly simple syllogism overlooks one of the essential timbers in the American constitutional structure. As the Supreme Court held in 1833, the Bill of Rights, at least directly, only applies to restrict the power of the federal government vis-a-vis individuals. Insofar as we enjoy constitutional protections from state and local governments, we do so because the 14th Amendment incorporates some of these rights, such that the Bill of Rights restrictions, or at least some of them, are applicable as against the states. Hence the quite difficult question in McDonald's whether the 14th Amendment incorporates the Second Amendment to apply it against the states. With McDonald, it's hard to know where to begin. The opinions amount to a riveting, and I say that with no intended cynicism or irony, a riveting 100-page distillation of 14th Amendment jurisprudence and its oftentimes turbulent, unsettled history. The opinions include eloquent and not so eloquent defenses and critiques of the method of constitutional interpretation known as originalism. The opinions include Justice Stevens' valedictory, a tour de force that attempts a fundamental reworking of 14th Amendment jurisprudence. Confronted with such riches, I cannot help but identify only a few things to say and let the panelists flesh out your McDonald education. The facts of this case are quite easy. Chicago had essentially the same handgun ban as the District of Columbia did, essentially refused to permit anyone to possess a handgun within city limits. So the question is whether the Second Amendment applies to void this ban, applies to the 14th Amendment to void this ban. So the main question, does the 14th Amendment extend the Second Amendment's protection of an individual right to possess firearms, including handguns, to safeguard individuals against state and local governments? Because of an oddity of 14th Amendment jurisprudence, this main question subdivides into two sub-questions. To someone unversed in constitutional law, this question would seem to require an interpretation of the 14th Amendment's Privileges and Immunities Clause. The Privileges and Immunities Clause provides that a state may not abridge the privileges and immunities of citizens of the United States. It was generally understood in the 1860s that privileges and immunities was another way of saying rights. So the Privileges and Immunities Clause essentially seems to incorporate the Bill of Rights, the rights of the citizens of the United States as against state and local governments. If rights in the Bill of Rights are indeed considered privileges and immunities of American citizens, then the 14th Amendment should extend their protections, including the Second Amendment, to the states. But in the slaughterhouse cases in 1873, the Supreme Court turned the Privileges and Immunities Clause into a constitutional flotsam, to quote Justice Scalia, or an ink blot, to quote Robert Bork. Privileges and immunities of citizens of the United States included only citizens' abilities to interact with the federal government. Thus, for example, a state could not interfere with someone's ability to access a post office. But that's basically all the clause does, which is odd given how much debate it caused in Congress. So the first sub-question is, should the court reinvigorate the Privileges and Immunities Clause from its 140-year dormancy? If no, the second question then becomes, should the court conclude that the Second Amendment is incorporated into the 14th Amendment's Due Process Clause? The Due Process Clause provides that a state may not deprive someone of life, liberty, or property without due process of law. It's a much more textually awkward way to extend the Bill of Rights protections as against the states. But because of the slaughterhouse cases and a couple of other cases that were issued during Reconstruction, when the Supreme Court seemed to try to destroy the efforts by the radical Republicans to come up with a more powerful federal government, because of these cases, due process is the only avenue open to do so, to incorporate the Second Amendment. And hence it was the avenue chosen by the United States Supreme Court over and over again, especially in the Warren Court days, to extend these rights as against the states. There are 5 opinions in this case. Justice Alito wrote a plurality opinion for himself, the Chief, and Justices Kennedy and Scalia. Justice Scalia wrote a concurrence, as did Justice Thomas. So there are 5 votes to strike down Chicago's ban and incorporate the Second Amendment. Justice Stevens wrote a solo dissent, and Justice Breyer wrote another dissent on behalf of himself, and Justices Sotomayor and Ginsburg. Justice Alito wrote the plurality opinion concluding that the Due Process Clause does indeed incorporate the Second Amendment. First, he declined the invitation to awaken the Privileges and Immunities Clause from its 140-year-old nap. He did so despite the general opinion that it was written precisely to extend, if not the Bill of Rights themselves, at least things akin to the Bill of Rights, to the states. There was no need to disrupt history, Justice Alito said, since the due process avenue remained open for the Second Amendment to travel. Second, Justice Alito canvassed the history of due process incorporation doctrine to distill a test from it. Whether the Second Amendment applies to the states depends on whether, quote, the right to keep and bear arms is fundamental to our scheme of ordered liberty, which Justice Alito equated to the following, whether this right is deeply rooted in this nation's history and tradition. It's important to note the equivalence that Justice Alito drew between, quote, fundamental to our scheme of ordered liberty and, quote, deeply rooted in this nation's history and tradition. You would be surprised to know that much of this decision, much of the 100-some-odd page of this decision, were really arguing about gay rights in Lawrence versus Texas. I don't know the necessary connection between handguns and gay rights, but I guess there is one. The formulation that Justice Alito chose would, for example, enable him to claim that Lawrence versus Texas was wrongly decided. Third, Justice Alito answered his own test in the affirmative. Self-defense is a basic right as recognized from ancient times to the present, and guns are the preferred firearm for protecting oneself. Justice Alito hits on some high points from about colonial times from the Heller decision. He then stresses the experience of freed slaves in the South right after the Civil War, the terror that they lived under, and the recognition by the authors of the 14th Amendment that they needed firearms to defend themselves as evidence that the authors of the 14th Amendment intended to protect citizens, including those newly freed slaves, by vesting them with a right to individually possess firearms. Justice Scalia concurred basically to defend his method of originalism against Justice Stevens' critique and to insist that any other method of constitutional interpretation smacks of untrammeled judicial activism. Now, interestingly, Justice Scalia did not adopt the Privileges and Immunities Avenue. He said, I will accept that the Privileges and Immunities Avenue is closed to us, even though I'm doubtful that the court interpreted it correctly in the slaughterhouse cases. So even as he defends his originalist methodology, he accepts that an unoriginalist method of incorporating the Second Amendment through the Due Process Clause is the only way to go. Justice Scalia wanted to prove, as he said in 2008, that while he's an originalist, he's not a nut. Justice Thomas, on the other hand, is a nut because he accepted the Privileges and Immunities argument and wrote a concurring opinion to argue that it should be reinvigorated and awoken from its lengthy slumber. Justice Stevens wrote an eloquent dissent. Justice Stevens denied that there exists something called incorporation at all. What the court was doing in its so-called incorporation cases was really something called substantive due process. If I have to give a basic introduction to substantive due process, in addition to everything else I have to do today, my head will explode in 9 different directions. But basically, the question is whether the 14th Amendment itself guarantees an individual right to possess firearms. The protection of liberty in the 14th Amendment guarantees a number of fundamental rights, Justice Stevens says. Some of these are mentioned in the Bill of Rights, some are not. The question is whether something analogous to the Second Amendment right is one of these substantive due process protections. There's no time to do justice to Stevens' remarkable reconstruction of substantive due process doctrine. This is just to say that I take his opinion as an effort to provide a workable framework not dependent on some narrow originalism of this all-important constitutional doctrine. Finally, Justice Breyer took on the plurality on its own terms and concludes that the Second Amendment is not in fact incorporated. Before I close, let me suggest one way in which this opinion reflects how law and politics are a continuum and not a dichotomy. Several prominent legal historians have argued that the Supreme Court tends to track political opinion quite closely, and that its individual rights jurisprudence is a particularly illustrative phenomenon, example of this phenomenon. Consider how public attitudes regarding gay rights changed between Bowers versus Hardwick in 1986 and Lawrence versus Texas in 2008, to use a case that was obviously quite important to the justices as they drafted this opinion. In 1986, 55% of Americans favored laws prohibiting homosexual relations. In 2003, 60% of Americans favored laws legalizing homosexual relations, a fact that I'm sure was not lost on the members of the majority in the Lawrence versus Texas case. Consider how public attitudes regarding segregation changed between 1927, when the court approved segregated schools in Gong Lum versus Rice, and 1954, when it voided segregation in Brown versus Board. In 1927, we had yet to fight a world war against forces of racial oppression. In 1954, we were enmeshed in a global struggle against the Soviet Union, fighting for the hearts and minds of the Third World. In 1954, Jackie Robinson was one of the country's most popular athletes, in spite of the fact that in 1927 he would not have been allowed anywhere near the baseball diamond. McDonald reflects the same relationship between political and jurisprudential change. Almost half of Americans surveyed in the late 1980s supported a ban on ownership of handguns. In 1990, the former Chief Justice Warren Burger went around calling the idea that the Second Amendment protects an individual right to possess firearms one of the greatest pieces of fraud on the American public I have ever seen in my lifetime. In 2008, in contrast, 73% of Americans believe that we have a right to own handguns. I think that I'm not suggesting a facile connection between changed public opinion and the way the Supreme Court decides cases, but I think it's an important fact to keep in mind as you evaluate the grand scope of constitutional history.
Thank you again, Professor Marcus. Judge Wake, what do you think the significance of Justice Thomas's concurrence in his reliance on the Privileges and Immunities Clause is?
Well, first let me say that I agree with Professor Marcus. This is a grand case. If you put aside whether you like or dislike the outcome about handguns, it is a grand case in its summation of the evolution of history of incorporation or the meaning of due process under the 14th Amendment and a revisitation of the slaughterhouse cases. The slaughterhouse cases are just wonderful. We didn't touch on the merits, but briefly, a bunch of people went out and bribed the Louisiana legislature openly to grant themselves a monopoly on slaughtering in the city of New Orleans, and the people who were driven out of business, were unhappy about that. As it turned out, the bribery was so open that some of the bribers defaulted on their allotted shares to the bribery, and some of the people who had advanced the money sued the defaulting bribers in state court for their defaulted shares, and the state court said that this is too much even for Louisiana. So they threw that case out. But later on, when the statute came through, the Louisiana Supreme Court said, well, that's what the legislature said, and that's how it got to the Supreme Court. And as we know, the Supreme Court, when they got there, were simply unable to envision a world different from the world before the 14th Amendment. Virtually everything that they said about the 14th Amendment has since been overruled, and everything they said about the slaughterhouse cases, about the Privileges and Immunities Clauses, is not everything, but a lot of it has just been left. So as everyone has said, there's been a lot of scholarly interest in this in recent years. I think Justice Thomas was right in the abstract, as he is on a variety of things, that he is willing to leap beyond where the law has gone and go back to where it should have been. That as a matter of historical purpose, he's probably right. I'm not saying I would agree with him that makes an automatic incorporation of all of the Bill of Rights. I think that's problematic even for a Privileges and Immunities Clause analysis. But the problem is that the law is a river that cuts its own channel over time, and we've got 130 years of a channel cut in the law here. And obviously the majority thought it is too much work to go through a massive paradigm shift that would affect so much jurisprudence. Now, your question, Sally, what do I think? I'm going to offer the thought that it doesn't really matter much. Now, the plurality opinion basically, I think, has a thesis that's basically a traditional incorporation theory, but really with the Bill of Rights on steroids. You're really paying a lot of attention to the Bill of Rights, although there are some of the Bill of Rights that have never been incorporated and wouldn't be even under this analysis. And Justice Thomas pretty much comes to the same conclusion, very strong. It's almost like Hugo Black Light, where it's heavily on the Bill of Rights but not total incorporation. I submit that the reality is that having gone down what is probably the wrong channel way back in the slaughterhouse cases, and then having gone through a long time of resurrecting or creating a new vision of due process, the court has constructed a lot with a thin text. And it has been relying on things like fundamental principles of justice and whatnot, fundamental to our system of justice, that relies on judicial judgment about the nature of our society, of our vision of justice, and that requires judicial choice. You can't get around the judicial choice. I submit that Justice Thomas's view would do a lot of the same. You would still be having to fall back on what is judicial choice and judgment that lacks this illusion of certainty from the text that Justice Scalia and others, and Justice Hugo Black in particular, thought that could be found. So that's my long answer. I don't think it would make much practical difference in the outcome.
Dean Massaro?
One thing that was talked about beforehand was that if you locate a right in the Privileges or Immunities Clause, it doesn't attach to corporations or aliens. And so you really only have 4 votes for the Second Amendment being incorporated in a way that would apply to aliens and corporations' right to bear arms. Then that's interesting. Will it matter? I don't think it will. Does the fact that it was a plurality opinion, is it going to really make a difference in terms of how local officials interpret their responsibilities? That it was 4 votes, not 5? I don't think so. Here's what I think should matter, and it would be the implication for constitutional theory. To look at, in good faith, the Privileges or Immunities Clause, and to take seriously the argument that it's the better home for these rights than the Due Process Clause, which many people, bipartisan, have concluded, and to reject it, as the court did here. And for the conservative justices to reject it, I think you could say, and this is where it's good to be a professor and not a practitioner or a judge, this is the death of all but the faintest beating heart of originalism. Be gone. That's the end of you. And here's why it's the end of you. You can't say that the reason that we're going to reject looking at this text is because there's been this intervening period. When's it enough? 100 years? 15 years? 20 years? We've been getting it wrong. And we have this body of case law. It'd be just too much work for us to dig out from under this. I agree 100% with the court's conclusion. Before the case was ever decided, Justice Scalia was here, and it was clear that where he was going, just in a small conversation about it. It doesn't make sense. So what does that mean? In 1997, Jeff Rosen said, we're all originalists now. It was right after Justice Scalia had delivered the Tanner lectures that he'd written his book. But in fact, if here in 2010, if we check in on the Originalist Project, first there are multiple versions of it, and the people who are now claiming the mantle of being originalists are people like Larry Tribe and other so-called or more described liberal Balkan, etc., jurists. We've seen 13 years of judges like Justice Souter going after the original intent arguments toe-to-toe. We saw it in Heller, where the majority opinion and the minority opinion took the originalist historical arguments, went toe-to-toe. And in this case, likewise, we'll see it again in Citizens United toe-to-toe. Nobody is moved. It doesn't, in fact, end up being determinative. It's evidence. It's relevant. But ultimately, to make sense of these original documents requires a kind of practical perspective about what law is. And it also requires a kind of expertise that most judges, lawyers, and the justices themselves lack. True historians disagree with each other. And the history on the Privileges or Immunities Clause is rich and inconclusive. So had they gone to the Privileges or Immunities Clause, not only might it not have mattered in the way Judge Wake says, but they would have been going down the rabbit hole of confusion about which historian's account of what these rights look like should we credit. And choices among those accounts have subjectivity all over it as well. What has happened with the fact that it is Justice Scalia and Justice Thomas on the court? What's happened is we've been revocabularized. It's like Freud. Everybody can talk like Freud, but that doesn't make you a psychoanalyst. Or, in a more pertinent to law way, economics. People talk about the relationships using language of cost, benefit, sunk costs, et cetera, and I think that what's happened is lawyers have had to become much more fundamentally revocabularized as historians and to use and draw these texts into the argument, but I would submit that it's no more radical to draw history into it than it's radical to bring in social science. It is ultimately more external to law. That's the definition of when the legal realists were looking at what they think a judge does, that it might be external to law, and that's problematic and that's radical. My point is I think drawing history into it doesn't make it any less radical, any more coherent, any more predictable, any more stable, or any less activist. And the proof of it, I think, will become clear when we get to Citizens United and the Elena Kagan confirmation hearings. Wasn't it interesting? Everybody accused everybody of activism. And the historical trope doesn't do anything to prevent that from being part of the discourse now. So I think that McDonald is the best case that I would cite heretofore against static forms of originalism. Common law, constitutionalism, evolutionary approach to law happens. See example, McDonald. This is constitutional dynamism on stilts. How else does due process of law become the First Amendment? How? How else does post-18th century evolution of thinking about gun possession become the best theory to support the Second Amendment individual right to bear arms? It's like a reverse dynamism constructionism. And so I don't think that plain meaning originalism has the break or provides the break that they hope. Judicial restraint is only a virtue if it serves an underlying goal worth preserving. It's substantive, the notion that we care about judicial restraint. And the search for historical text to anchor you is a way in which those who think plain meaning originalism is the answer, and I'm quoting Roberto Unger, you are worshiping at cold altars. See example, McDonald, in which Scalia is not even with you in church.
Ms. Mahoney?
I actually didn't think that McDonald was a surprising case at all. It was just Heller. Heller was the case. It was decided, and once Heller was decided, you knew what the answer was going to be in McDonald. The only thing that there was a buzz about was would the court do something that was more radical and basically remake the law and go down the privileges and immunities path. But there's a difference between, of course, originalism as a theory of constitutional interpretation and stare decisis, and really what the plurality was saying is, despite a scholarly presentation by Justice Thomas, we're not going to go there for reasons of stare decisis, in effect, without doing the full analysis. But the decision is interesting. I agree with you that because this is all a defense of Heller, really, and the defense of different styles of constitutional interpretation, for constitutional law students in particular, I think reading these decisions is a great way to get a real handle on what the debate is between the different ideological factions of the court. Because, I mean, Scalia puts it this way at one point. He says, really the difference here is a theory, mine, that makes the traditions of our people paramount versus vague ethico-political first principles, which is what the other side relies upon. And others can say, well, you know, that's just bunk. But Justice Scalia does point out that, okay, history may not tell you the answer for sure. It may be ambiguous in various settings. And many would say that that's true in Heller, although he would say it's not. But he says sometimes it's absolutely clear what the answer is if you allow history to be the guide to how you would interpret the Constitution. And an example of that would be for those who would say that the death penalty is flat out cruel and unusual punishment. How can you say that when at the time of the adoption, the death penalty was, of course, in vogue and was specifically referenced in the Constitution? So history and tradition does do a lot of work in many cases that if you abandon that and say it's not relevant and just go with instead some sort of contemporary notions of justice, you're going to have a very different form of constitutional interpretation. So I think it's a really useful thing to read. And just to see where they're coming from. And he does make this point repeatedly. I'm not so sure he does it in this opinion, but think hard about what it means if you say that constitutional interpretation should be governed by just sort of a contemporary sense of justice, both here and abroad. What does that do to the provision of the Constitution that says what needs to be done to amend it? That you have to have, 3/4 of the states and go through this process. If instead justices have been empowered to just decide sort of what the public consensus is in their view right now, haven't you really written that out of the Constitution? And these are very hard problems, and I think that the decisions in this case actually nicely sort of spell out the debate.
Thank you. Well, I'm going to throw this out to whoever on the panel would like to answer it, but there's been some criticism of the court's decision in Heller, which we would agree McDonald was really about Heller, as being, some have compared it to Roe v. Wade in the sense of it being an example of judicial overreach. Anyone care to take that one on?
Well, I wouldn't call it overreach, but I think it's fair to say that reading Heller, the evidence is inconclusive. There's a lot to be said on both sides. And that when I read both opinions say, that sounds right. So then the question may become, if things are inconclusive, what are the default values that the court should follow in deciding these questions? So I don't give you an answer, but it's a significant substantive decision.
Professor Marcus?
Yeah, sure.
I think it depends on how you define overreach. If you define overreach as sort of purely legal overreach, then I think the argument is quite strong that Heller and then its derivative is not in a pejorative sense, but derivative opinion in McDonald is a sort of a conservative analog to Roe in the sense of judges putting their own imprint on an ambiguous text with conflicting evidence. If you think of overreach, if you situate the decision sort of in the political moment more generally, which is obviously the theme I'm trying to push this afternoon, then I have a hard time seeing how Heller is the equivalent of Roe versus Wade. In retrospect, it seems as if Roe versus Wade it kind of cut off a certain political movement towards gaining some of the rights that the decision protects, constitutionalizes through the legislative process. That's the sort of the typical legal process critique of Roe versus Wade. Now it's hard. That's retrospect from 40 years later. In 1970, in the early 70s, when Roe was decided, it wasn't until the end of the 70s that evangelical Christians saw Roe versus Wade as an issue that they wanted to rally against. In fact, when the decision was first announced, most evangelical groups were silent on that issue because the Catholics were against Roe versus Wade, and anything the Catholics were against, the evangelical Christians were for. So I may be wrong about my assessment of Roe, but it's hard to see that Heller and then McDonald are going to serve the same function as cutting off some kind of incipient political movement. It's almost impossible to imagine a mainstream candidate for president these days running on a position of strict gun control. President Obama certainly hasn't, and I know of no major political candidate and major political force in either of the houses of Congress who's advocating for strict gun control either. And so I don't see. It seems like this is an example of an opinion that arrives after the political moment crests, rather than before it, as arguably is what happened in Roe versus Wade.
If I could just speak to that, I think that maybe what you're seeing is not so much the jurisprudence of the majority of the court being correlating with popular opinion, but rather that there tends to be a correlation between the jurisprudence of Justice Kennedy and public consensus. And he gives credence to that in a variety of areas. He tends to be the swing vote in all of these cases. And in many of the cases where he has sided with the liberal wing of the court, for instance, on issues like whether or not you can imprison juveniles for life, for crimes, other than murder, that sort of thing, he will be. He'll say that the public, sort of the emerging public consensus has some bearing on how he interprets the Constitution. So I think it may be you're tracking Justice Kennedy more than the court itself.
Dean Massaro?
I agree with Dave. I don't see the analogy. But backing up to what Maureen said, I don't deny that there's a difference between somebody who starts out with, if I look at history, I get the answer, and somebody who thinks it's irrelevant. I just think it's cartoonish on both sides. I don't think that the people associated with originalism, Scalia being a good example of this, not the best example, but an example, in fact, is applying it in the way some people imagine originalism to work. He is better described as a traditionalist, and that's not coterminous. And what my point was is that what we see in McDonald, which I think is correct as a descriptive claim, is an evolutionary process, that it's constitutional common law evolutionism that's going on, and that we'd be better off if we got out of the argument about whose fidelity to the Constitution is firmer. A lot of liberal constitutional theorists are self-proclaimed originalists in that. I don't think much of anybody thinks you don't look there as a starting point, that you don't consult history. Question is, what do you do in the crevices and the interstices? And I thought that Justice Kagan answered this beautifully this summer, where it came down to it, and she talked about the judgment that goes into those determinations in between one or the other. And it was very Cardozo-like to me, in which how she explicated what she thinks judges do. Scalia himself has said, I cannot deny that stare decisis, which he admits he adheres to, which makes him not a pure originalist, affords some opportunity for arbitrariness. I just attempt to constrain my own use of the doctrine by consistent rules. And if you peel it back, just to use him, what is it that he's against? What his approach to the Constitution and constitutional amendment and the theory that Maureen accurately describes is he ends up being against not what he regards as novel constitutional rights. And he thinks we're in the presence of that when we can find a specific historical practice that the framers knew existed when they adopted a rule and didn't think applied to the rule. And he gives us the example, cruel and unusual punishment. He rarely in those addresses, when he talks about it, goes to the question, what do we do about the ladies? What about women? What happened? Is that something that's just an application, like ramped up technology affects what we think about guns? Or, and therefore our notions of citizens change as we expand our concept of it? Or is it more like cruel and unusual, this is what we did then and we should be able to do that to women too? And how you answer that question suggests how much evolution you permit, what level of generality, how specific does the practice have to be before you call it traditional. And the novel constitutional rights he's against, he doesn't think the Second Amendment as construed as self-defense in the home is novel. There's some evidence that it is. Is it the better view they landed in Heller? I don't think so. Does it make sense to apply it by the 19th century under the 14th Amendment? I do think so, as an individual right. I think the post-1787 and 89 practices are more illuminating and better defense of the individual right to bear arms than anything that existed before the Second Amendment was adopted, because of the black codes and because of the violence against the recently emancipated African Americans and also the whites who defended them. But you can't consider that post-adoption history as relevant in articulating the meaning of the Second Amendment unless you believe that evolutionary process is relevant to it. And that's the point I was making. He's against striking down same-sex schools. He's against protecting same-sex relations. He's against protection of abortion and denying government the right to affirm religion writ large. That kind of stuff. He regards those as novel constitutional rights, and I think people in good faith can disagree about that. But I don't think you can be a pure originalist and buy into McDonald. Thomas is your last hope.
Judge Wake?
Isn't part of the answer that the relevance and strength of originalism in constitutional law varies from obvious and dispositive to attenuated, just as it does in other areas of legislation? So, for example, we're used to interpreting statutes looking for a specific meaning of the legislature, and that's what we usually do. But there's legislation that doesn't work that way. The antitrust laws are essentially a mandate to the courts to create consistent bodies of economic of rules to promote competition. And why could not there be the same variation in the Constitution? So, for example, the Constitution says that the House of Representatives shall consist of members apportioned to the states according to their population. That sounds like the paradigm of an originalist term of the Constitution. It's actually open to debate now. Because Congress came close to adding a voting representative from the District of Columbia, which is not a state. But there are other provisions, whether it's the Privileged Immunities Clause or equal protection, that if it are simply, you can't pin it down to what people were thinking about in 1868. As you said, Toni, the materials are diverse, and there's a rich body of secondary materials on the history of the 14th Amendment, and you read it all and various stuff, and lots of people had lots of ideas, and it's really hard to say what the legislatures, three-fourths of the legislatures were thinking when they ratified it. So perhaps things like equal protection and privileged immunities are on that somewhere, not on the easy end of the spectrum of determining original intent, and somewhere down the spectrum of entrustment to cautious judicial rationalization in current circumstances.
Nice summary, Judge Wake. And on that note, we're going to take a break and for about 10 minutes. I think there's water outside if you want to get up and stretch your legs, and we'll reconvene at 3:35.
If you're feeling somewhat worn out by, it's the mid-afternoon, you might be feeling a little bit tired. We've been talking about the Supreme Court for a couple of hours now. There's no way to energize you better than to talk about Free Enterprise Fund versus Public Company Accounting Oversight Board. The free enterprise case, in some sense, reflects a central tension in American administrative law. We want agency administrators to act with technical competence and expertise, but we're fearful of agency power not subject to political checks. The opinion in this case tries to straddle this tension, produces an unwieldy answer, but one that I think is ultimately a pragmatic one. Formally, the case involves limits on the president's power to dismiss members of the Public Company Accounting Oversight Board, or PCAOB, as I'll call it, or I think others call it too, an agency working under the aegis of the Securities and Exchange Commission. But more broadly, the case, in some sense, involves much more fundamental questions. And I think it makes the most sense if we talk about three background subjects. First, independent agencies. Second, the law that regulates independent agencies. And third, the theory of the unitary executive. So what exactly are administrative agencies? The United States Constitution provides for three branches of government, as we all know. So where do agencies fit? It's tempting to say, well, let's just look to Article 2, Section 1, which provides that the executive power shall be vested in a President of the United States. We often think of agencies as executive branch institutions, subject ultimately to the control of the President, and thus fitting comfortably within Article 2. And while this is true for plenty of agencies like, say, the Department of Defense, it is simply not the case for others, like the SEC. There are plenty of so-called independent agencies, of which the SEC is an example. The SEC has 5 commissioners, each of whom is appointed to a 5-year term. The terms are staggered, so no president could possibly appoint all SEC commissioners. And moreover, the president can only dismiss an SEC commissioner upon a showing of good cause, not at will, as is the case for other department heads. In other words, a commissioner can only be dismissed on grounds of inefficiency, neglect of duty, or malfeasance in office, and not because he or she pursues policies the president, as leader of the executive branch and in theory responsible for executing the securities laws, disagrees with. The SEC, in other words, is an independent agency. Its officers are not removable at will by the president. The agency itself is not totally subject to presidential control. Independent agencies have existed since the 1880s, but we have yet to come to exactly to constitutional grips as to what they are, where they fit within the terms of the Constitution. The law regarding independent agencies does little to clarify their constitutional status. In 1926, Chief Justice Taft, who of course had been president himself, insisted that all heads of agencies must be subjected to presidential control and that presidents must have complete authority to remove the heads of agencies. But 9 years later, in the midst of the New Deal, explosion in the size of the American administrative state, the court appeared to reverse course. In Humphrey's Executor versus United States, a 1935 decision, the court held that Congress could restrict the power of the president to remove members of the Federal Trade Commission because those members exercise quasi-legislative and quasi-judicial powers. The FTC promulgates rules, which is like promulgating legislation. The FTC holds administrative hearings, which is like deciding cases. The FTC, in other words, is not wholly executive, so it's not squarely part of the executive branch subject to presidential control. More recently, the Supreme Court has gone out of its way to uphold restrictions on presidential power. In Morrison versus Olson, a 1988 case, the court upheld the independent counsel statute. The independent counsel statute was one of the Watergate reforms designed to protect against the excesses of the Nixon administration. The most famous appointee to this position, of course, was Ken Starr. More about him in a minute. The law provides that the Attorney General could only remove an independent counsel for good cause. This law was challenged, and the court stressed that since the president could remove the Attorney General at will, essentially the president essentially could wield some modicum of power over the independent counsel, him or herself. The law did not, quote, unduly interfere with the president's exercise of executive power. In academia, particularly among those who insist on an originalist reading of the Constitution, cases like Morrison are an anathema. These scholars insist upon a unitary theory of the executive. Agencies like the FTC and independent counsel undoubtedly execute the laws. The Constitution recognizes the president as having plenary power to execute the laws. There is a unitary executive in the Constitution, not one divided between the president and so-called independent agencies. Thus, as a matter of simple constitutional law, the president must have unfettered control over the agencies, including control to remove agency's head at his or her discretion. One can describe advocates and opponents of the unitary executive theory as arguing over a very basic idea about the administrative state. Should ours be an administrative government dominated by expertise and technical competence, an ideal that requires some political insulation in order to work? Or should our administrative state be politically accountable through presidential elections, a status that sacrifices technical prowess to democratic legitimacy? The free enterprise case gave some hope to advocates of the unitary executive theory that the Supreme Court would get rid of cases like Humphrey's Executor and Morrison versus Olson and embrace their quite expansive view of presidential power. But unlike in Citizens United, which we'll talk about later, the court balked at such a dramatic remaking of the American governmental fabric. In the wake of major accounting scandals involving Enron and WorldCom, scandals that seemed quaint after the 2008 recession, Congress created the PCAOB as part of the Sarbanes-Oxley Act of 2002. It's not worth going into the details, but essentially PCAOB basically promulgates accounting and auditing standards and can inspect accounting firms. If it finds irregularities, it can essentially commence criminal prosecutions and the like. Here's the key. PCAOB is led by a board of 5 members appointed to staggered 5-year terms. PCAOB's members, and appointed by the SEC commissioners. PCAOB's members can only be removed by SEC commissioners upon a showing of good cause. Here's the trick. SEC commissioners themselves can only be removed by the president upon a showing of good cause. In other words, there are 2 layers of good cause protection guarding against the president removing PCAOB board members if he or she wants. It would be one thing if the president could directly remove PCAOB's members for good cause. This would be Humphrey's Executor. It would be another thing if the president could remove SEC commissioners for at will, and if they could remove PCAOB members for good cause. This would be Morrison versus Olson. But here are 2 levels of good cause protection, making it quite difficult for the president to exercise any meaningful control over PCAOB board members. An accounting firm subject to an enforcement action claimed that this peekaboo structure interfered with the president's executive power. Ironically, the accounting firm was represented by Ken Starr, who earlier had been appointed pursuant to the independent counsel statute to the independent counsel position. So he benefited from the Morrison versus Olson case, which enabled him to embark on a multi-year investigation into the vast ambiguities and mysteries of oral sex. Chief Justice Roberts, writing for the majority of 5 conservative justices, agreed that the peekaboo structure violated the Constitution. There's some language in the opinion that suggests that Roberts would love to have embraced the unitary executive theory. The problem isn't the double for-cause layer of protection, but rather that agencies cannot be independent of the president. But Roberts doesn't go this far. He says one layer of for-cause removal restrictions is fine. It's okay if there are some restrictions on the president's power to remove officials. But 2 layers of good cause protection is too much. The president could believe that a peekaboo member was neglectful of his or her duties, but if the SEC commissioners don't do anything, there's nothing that the president could do. The president cannot remove an SEC commissioner at will who refuses to remove a peekaboo board member, and the president cannot remove the peekaboo board member himself directly. This double layer of insulation strips the president of the ability to execute the laws by holding his subordinates accountable for their conduct and is thus unconstitutional. So we're left with a clear rule of law, if somewhat of an anomalous one. Independent agencies are fine so long as there's only one layer of good cause protection for their heads. But while this is ostensibly in the name of presidential power, it leaves quite an odd result in this case. It's now understood that the SEC commissioners have the power to remove peekaboo board members at will. The president can remove SEC commissioners, but only for cause. So if a peekaboo member does what the president wants, but SEC commissioners don't want, there's nothing the president can do if the commissioners remove the peekaboo board member, provided the commissioners are not committing some sort of malfeasance. At any rate, the opinion in my mind represents a necessary, inelegant compromise between 2 visions of an administrative state. The opinion preserves a modicum of good cause protection for the agency administrators in the name of technical efficiency, but it insists upon a modicum of presidential control in the name of democratic legitimacy. What results is an odd structure that doesn't really make sense by this metric, or any metric, but makes ample sense in this particular instance. But it makes ample sense as a manifestation of a compromise between democracy and technical expertise. A compromise born not of any text in the Constitution. The Constitution, after all, does not provide for independent agencies, but out of political and bureaucratic necessity.
Thank you, Professor Marcus. And my first question goes to you. Why is this case important?
I have no idea. I asked that myself a few nights ago when I was struggling to make my way through the arcane details. It's actually really important for 2 reasons. One, as a matter of purely administrative law, it's important for its very tepid embrace of the unitary executive theory. Basically, administrative law now is very clear as to how heads of agencies can be controlled by either Congress or the president. We now know as a clear rule that Congress cannot control the actions of administrative agencies. Once they delegate power to administrative agencies, that's it. It's over. They cannot retain some control short of formal legislation to control the activities of agencies. We also know that they can create structures by which they protect agencies from presidential heavy-handedness. So they can create independent agencies that can function somewhat independent of presidential control, and we know what they're allowed to do and what they're not allowed to do. So that's important for the structuring of these independent agencies going forward. As a political, or I use the term political, and I think we might have a disagreement about what this means in the short future, but as a sort of political sciencey reason, I think it's significant because of its only tepid embrace of the unitary executive theory. There was a lot of discussion of this theory of the unitary executive during the Bush administration as this sort of very dangerous, threatening theory that, if brought into by the Supreme Court, would vest the president with this remarkable amount of power to do whatever it wants. I think that's a bit of an exaggeration, but that was sort of the political overtones of this notion of the theory of the unitary executive. This case, basically, the court had an opportunity to embrace the theory, declined to do so. I think that the idea that the president himself will enjoy total power to execute the laws in the future is unlikely to happen, and in all likelihood, this case is tantamount to a repudiation of the sort of full extent of that theory.
Ms. Mahoney?
I think it is hard to read the decision and say that there's something really satisfying doctrinally about the opinion and about the ruling, because for reasons that Professor Marcus has described, why does this really make a huge difference in a lot of fact patterns? But I think that for those who believe in robust executive power, in other words, and certainly Chief Justice Rehnquist was one of them, who read Article 2 as saying it is the president's responsibility to faithfully execute the laws, they looked at the landscape and said, you know what, this has been eroded through a series of decisions. We're not going to overturn them, but enough is enough. And here we're faced with a new fact pattern that really does mean that the president has essentially, no authority to exercise any removal power, even for good cause, and that's just a bridge too far. And I think that the fact that the United States, at argument, suggested that even 5 levels of for-cause removal might still not create an Article 2 problem was further incentive for the court to say, we just can't let this one go by. So I think, I don't know what it's really going to mean for other fact patterns, but this one, they just said no more expansion of this doctrine that really erodes the president's express textual responsibility for faithful execution of the laws.
Can I ask you another question with your experience in the SG's office, that here you have this independent agency and the SG's office is tasked with defending statutes if there's a reason to think that they're constitutional, but this really is something that maybe the president might have taken a different view and said, no, I think this is unconstitutional. How does that play out with the independent agency in the SG's office? Is it the Department of Justice that makes that decision, even if you have an independent agency?
Well, it depends on the particular statute, but generally speaking, the Solicitor General can allow the independent agency to have their own counsel to represent them in the Supreme Court, decide, in other words, that if they have a different view of what the answer might be, they can have a different advocate. And I thought that it was interesting that in the Roberts opinion, he does, in essence, address the issue of why is the president defending the erosion of power in this case, and he essentially says, look, if this president wants to give away his power, that's maybe his choice, but we're not bound by it because it's our responsibility to preserve the constitutional authority of the office of the president, regardless of what the views of this president might be.
Thank you. MASSARO?
I think Maureen's spot on. I think that it's hard to see this is doctrinally, here's how it'll be anthologized. It'll be put in for the narrow point that Professor Marcus says. You can't have the double for-cause removal. And then you might have questions after saying, well, speculate, what does this mean? And they'll say, a bridge too far. But that's an important move. You see, when early part of substantive due process, you start to see the more ostensibly conservative justices saying, okay, I'm going to observe stare decisis, but I'm not adding anything to the list. And that is a very important, the flag goes up. Breyer thought it was a very big deal. And I think there must have been a lot going on within the court that made it worth his while to file this long, with appendices dissent, and say that this case's result is wrong, very wrong. He saw this as a big deal, and so I think nestled in the undergrowth is they live to fight another day, and between everybody agrees it's a unitary executive. The question is how unitary, and what do those powers include? A strong, robust version or a narrower version. The other thing that I think is interesting is that there were no concurring opinions. I'm not the only one who's observed that. I mean, Scalia didn't write separately, and so they've got a united front for something, and that something is saying we're not going any more than this, and we think it's a pretty powerful statement about executive power while preserving precedent. So I don't know. Maybe I just said I don't know. Judge Wake?
Judge Wake?
Well, I have nothing to subtract and only a little to add to what has been said. Justice Breyer used to teach administrative law at Harvard, so you can see he's beside himself because he knows what he's talking about when he wrote this dissent. To me, this looks like I phrase it like a warning shot across the bow to Congress. We're not happy with where you're headed here, and Chief Justice Roberts, his opinion talks powerfully about anxiety, about the unaccountability in the executive branch that has evolved, and echoes concerns have been voiced about lack of presidential power to change policy once you get elected, and particularly talks about legislative incursions into executive power, that power doesn't recognize any vacuums, and there's concern about Congress intruding. So I read it the same way everyone else has, that it's hard to say concretely what it's going to mean, but it's a sort of a change of tone from the court and a warning to Congress. Let me add a point of comparative law under the Arizona Constitution. Unlike the federal Constitution, which does not have an express clause about separation of powers, the Arizona Constitution does have an express provision that says there shall be separation of powers into the three branches. But also, unlike the federal Constitution, the Arizona Constitution does not have an appointments clause. The governor is not given the exclusive power to appoint people. So what we have seen in some cases that I know of is that the legislature does flow into this vacuum, and the legislature has created bodies with executive authority where they have retained to themselves the authority to appoint people to boards. So Chief Justice Roberts' comment about the fears of legislative intrusion, I think, reflect human nature and the nature of politics and the experience that's happened here in Arizona.
One other thing I just would reference about the decision is that in a term when there was a lot of uproar about the court being activist, and we'll get to that in Citizens United, I think there wasn't that much said, though, about how restrained the court was with respect to the remedy that they crafted in this case of the constitutional violation. The litigants, the whole purpose of the litigation was to establish that the board that was overseeing their activities was unconstitutional and that therefore its actions were void. And the court didn't buy that at all. Instead, they said, well, this just means that the board members can be discharged at will by the SEC commissioners. So it was really, they found that the provision, the offensive provision was severable, and that the statute otherwise remained intact. I suspect that the litigants thought this was a major disappointment, because I don't think that it really mattered all that much to the accounting firm whether the board members could be removed for cause or at will. So it was a restrained kind of remedy.
Maureen, let me ask you about that from the perspective of a lawyer. I would have thought that would have been obvious, that the remedy would be the least amount necessary to neutralize the defect. So what were they thinking?
Well, I didn't read all the briefing on this, but sometimes severability questions can actually be quite tricky, depending on how the legislation is written and those sorts of things. So I would imagine that they must have thought they had a real shot at it. Otherwise, they may not have invested that much in the litigation. Maybe I'm wrong, but I doubt this could be viewed as a major victory.
Right. Thank you.
The Wall Street Journal talked about that expressly, that there wasn't, they thought in the article that there wasn't strong enough evidence of severability. That would have been a big deal. Plus retroactivity would have been a big deal. And, it kind of, life went on. No one lost an eye. Nobody lost a paycheck. The chief did let us know how much they make, by the way. You left that out, Professor Marcus.
The members of the PCAOB make something like $600,000 each, which is great.
Nice work if you can get it.
Right.
But they can be discharged at will.
Right. Right. Just quickly on the question of significance, there's a very easy comparison between this case and a case called INS versus Chadha, which was decided in the early 1980s. And that was INS versus Chadha invalidated the legislative veto, a mechanism by which Congress required administrative agencies, after they promulgated rules pursuant to power Congress delegated to those agencies, to send the rules to Congress to wait for a period of time. If either House of Congress enacted a resolution disapproving of the rule would not go into effect. And the Supreme Court, in a bitterly divided case with a stinging dissent by Justice White, invalidated the legislative veto. And there are all sorts of claims in the academic literature and more popular commentary about the INS versus Chadha case that this was the road towards sort of agency tyranny. It was clipping Congress's wings way too much, and the ramifications of the decision were impossible to figure out and likely to be horrific. That didn't prove to be the case. When I teach this case in my very light version of administrative law class, it's hard for me to convince the students why it matters, viewed from 28 years later. And that's my guess as to what this opinion will amount to, that it's about an arcane way in which Congress structures an administrative agency, a way that the president himself, George Bush, an advocate of the unitary executive theory, did not notice when he signed the bill. He did not issue a signing statement on this provision, which is very strange given that his vice president, Dick Cheney, was probably the most aggressive advocate of the unitary executive theory that's ever inhabited that position. So my guess is that this case will probably be something included in administrative law textbooks, casebooks going forward, but unlikely to have much of a major jurisprudential impact.
Thank you. Now it's back to you, Professor Martinez.
Citizens United, which struck down limits on corporate campaign expenditures, is both a confirmation of and a challenge to my claim about law and politics, at least my claim about the relationship between law and public opinion. On the surface level, it's quite a challenge. One poll taken after the decision found that 80% of Americans disagreed with the result. That included 76% of Republicans. So there's bipartisan distaste for this decision. On another level, though, the opinions in the case support the idea of law and politics or law as politics by other means. The majority went well beyond what the particular case required. The voting broke down on 5-4 ideological lines. The majority opinion refuses to let something as annoying as precedent get in the way. The majority blithely brushed aside quaint notions of judicial modesty and minimalism. Let me start by doing the impossible and provide a quick and dirty summary of federal campaign finance case law. I stress dirty summary. Buckley versus Vallejo kicked things off in 1976, not dirty in the sort of pornography sense, but in the inadequate sense. Buckley versus Vallejo started things off in 1976. Buckley versus Vallejo includes over 200 pages of exceedingly muddled discussion, but there's a couple of key holdings. Restrictions both on giving and spending money in connection with elections are tantamount to restrictions on speech and can be justified only in the service of compelling government interests. The court held that amounts of campaign contributions could be limited to prevent corruption or the appearance of corruption. There was the real danger of a quid pro quo when someone directly gives money to a candidate. But limits on independent expenditures could not be justified by an anti-corruption interest due to a lack of evidence that independent spending could corrupt candidates. The court also rejected an equality rationale for limits on expenditures. The idea that some voices could be limited to enhance the voice of others to compensate for inadequacies of wealth or inequalities of wealth is something wholly foreign to the First Amendment, the court concluded. In First National Bank of Boston versus Bellotti in 1978, the court struck down limits on expenditures by corporations in ballot measure elections, non-candidate elections. In an opinion otherwise remarkable for its expansive embrace of corporate free speech rights, the court included an important footnote 26 that provides as follows. Congress might well be able to demonstrate the existence of a danger of real or apparent corruption in independent expenditures by corporations to influence candidate elections. The court elaborated on footnote 26 in an opinion Austin versus Michigan Chamber of Commerce decided in 1990. In this case, the court upheld electoral spending limits on for-profit corporations in candidate elections. The law was justified to prevent, quote, the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form. The court described this idea as an anti-corruption justification for the law, but it was really an anti-distortion justification to protect against inequalities of wealth distorting discourse in political elections. This almost seemed like the equality rationale rejected in Buckley. Austin was reaffirmed in 2002 in McDonald versus FEC. So federal election campaign finance law is incoherent before Citizens United, but there is this idea in Austin and McConnell that independent expenditures by corporations can be restricted in the interests of some anti-corruption rationale. I'm hopeful this summary will give you an appreciation for just how nakedly the court remade law in Citizens United. As is often true, significant cases are made of fairly silly facts. Citizens United is a far right-wing nonprofit corporation that receives some funding from corporate donors. It's run by a man named David Bossie. Again, the left-wing communist, Jewish, homosexual pornographer law professor. Don't take it from me. Take it from George H.W. Bush, who referred to Bossie as, quote, the lowest form of human life. Back in 2007, when everyone, including Hillary Clinton, thought Hillary Clinton would be the next president of the United States, Citizens United, with Bossie at the helm, made a film called Hillary the Movie. It's basically 90 minutes of talking heads trashing Hillary as the greatest socialist threat to American democracy ever. Haha, the joke's on Citizens United because the real socialist was in fact elected president. Citizens United wanted to make the film available on video on demand channel throughout the primaries and the general election. It would cost Citizens United $1.2 million to do so, and it, of course, would have to advertise its film to get an audience. The problem is that campaign finance law prohibits corporations and unions from making independent expenditures, that is, expenditures not coordinated with the campaigns themselves, that expressly advocate for defeat or election of a candidate within 30 days of the primary or 60 days of the general. Independent expenditures, again, are those not coordinated with the candidates themselves. Bossie and Citizens United worried about the legality of paying for the video-on-demand service and the advertisements. So Citizens United brought a declaratory judgment action to get a clean bill of health, arguing that restrictions on corporate independent expenditures, or at least the restrictions as applied in this instance, I stress as applied in this instance, violate the First Amendment. Following Austin and McConnell, the lower court ruled against Citizens United. The case went to the Supreme Court. It was argued twice, because the first time Citizens United did not argue that campaign finance law was facially unconstitutional and that Austin and McConnell should be overruled. The justices invited re-argument on this question. Solicitor General, then Solicitor General Elena Kagan, in her first appearance before any court, had to defend this cornerstone of federal campaign finance law. She and I have roughly the same experience litigating cases. Kennedy allied with the four conservatives to strike down this law as a violation of the First Amendment. All justices were true to form in their opinions. Kennedy writes with his trademark purple prose, crafting a paean to the First Amendment that is full of all sorts of what Justice Stevens describes appropriately as glittering generalities. The Chief's concurring opinion confirms my belief that he's the best legal writer since Robert Jackson. Justice Scalia somehow finds in the newsletter of the Society for the Relief and Instruction of Poor Germans, in print between 1755 and 1757, answers to all questions, First Amendment and otherwise. And Justice Stevens' lengthy dissent reminds me of his dissent in the Parents Involved case, a cri de coeur about a court he joined a long time ago that no longer bears a resemblance to a court he joined a long time ago that has changed beyond all recognition. I'll focus on Kennedy's opinion. After a fair amount of brush clearing, to establish that there's no way the court could have decided this case other than to address the facial constitutionality of this prohibition on independent expenditures, Justice Kennedy got down to business. First, he insisted that the expenditure ban is a ban on speech whose purpose is to, quote, silence entities whose voices the government deems to be suspect. Second, Kennedy reiterated a point that is hardly self-evident but nonetheless fairly well established, that corporations have a First Amendment right just as individuals do. Based on these 2 points, the the campaign finance restriction would be subjected to strict scrutiny and could only survive if there were a compelling justification for it. Third, Justice Kennedy concluded there is no such justification. As for Austin's anti-distortion rationale, that restraints on independent expenditures are necessary to keep corporations from dominating our public discourse, Kennedy noted that Buckley itself found equality in the marketplace of ideas something foreign to the First Amendment. Another possible justification for the restriction has to do with the idea that independent expenditures might cause corruption or the appearance of corruption, as recognized in Bellotti footnote 26 and then reiterated in Austin and McConnell. Kennedy brushes this concern aside. The only corruption that campaign finance laws should concern themselves with, he insists, is explicit quid pro quo corruption. I donate to your campaign, you vote for my desired law. Because this ban targeted independent expenditures, there is no quid pro quo corruption of this sort that can justify a restraint on First Amendment rights. Here's where Kennedy's opinion is breathtaking. When I presented this case to the University of Arizona's first-year class earlier in August, 100% of students agreed that a corporation's massive expenditures, even if not coordinated with a campaign, could lead someone once elected to feel obliged to support that corporation's interests. It's not just obvious to our students, it's also obvious to Justice Kennedy just last term in Caperton versus Massey, where he concluded that massive independent expenditures would lead to the appearance of corruption significant enough to require the recusal of a judge who benefited from such expenditures in a state Supreme Court campaign. But in Citizens United, Kennedy blithely concludes, without citing a single empirical source or data point, that, quote, independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. Further, the appearance of influence or access will not cause the electorate to lose faith in our democracy. What empowers a judge to draw such breathtakingly sweeping conclusions so profoundly at odds with common sense is beyond me. I don't have time to discuss the concurring and dissenting opinions, which is too bad because Justice Stevens' opinion is a magnum opus. Particularly good is his criticism of the majority for its cavalier attitude towards stare decisis. Among other justifications, Kennedy explained his disregard for Austin on grounds that it, quote, is undermined by experience since its announcement. As Justice Stevens points out, Kennedy cites nary a single piece of evidence in support of this claim, instead referring vaguely to, quote, rapid changes in technology and the creative dynamic inherent in the concept of free expression. As Justice Scalia once said, commenting on a colleague's flights of rhetoric, this is really more than one should have to bear. I've tried this year not to be too cynical in my presentation of these decisions, but it's difficult for me to see how this decision is anything other than a naked manifestation of ideology or politics disguised as law.
Tell us what you really think. Dean MASSARO, where do we go from here?
First, I think that it was predictable when the court called it back. Nobody really thought that something big wasn't going to happen. Second, in fairness to the majority, was the law coherent before this case was decided? No. If you go through, Susanna Sherry thinks, I don't actually share the view, but she cites this case and Lawrence as two examples of constitutional theory done right, and defends it in terms of 4 pillars of legitimate constitutional analysis. There was a lot of internal tension. Rick Hasen, who's a very well-known election law specialist, has written lots of work on this. It's a hard area to teach because of that internal theoretical, logical tension in the cases. So it isn't entirely true that they had undone 100 years of law, and that is why when President Obama said it, Justice Alito shook his head no. They had undone more recent law. There were factual distinctions that could be made between the law decided 100 years ago in this case. But the question, what now, is really an empirical question. I can't help but say, had McDonald been decided differently, that's the Second Amendment case, remember we were talking about earlier, and they were deciding whether to put it in the Privileges or Immunities Clause, the Second Amendment, versus due process. And I said one thing that would happen if they did, if the Second Amendment lives there, neither aliens nor corporations have rights under that provision of the Constitution. If you put the Second Amendment there, I think it would be inescapably the case that the rest of the rights would live there too, and thus would end the strongest argument for corporations to have free speech, because under the Privileges or Immunities Clause, they don't enjoy them. I think they would have found a way to give it back, but that's just to make sure nobody's gone to sleep. Okay. Now, what happens next? People who claim to know, I think. I've read a lot, and this is an empirical question way above my pay grade, because I don't work for Peekaboo. The conduct allowed now in Citizens United was allowed in 26 states before the opinion. What do we know about the relative distortion or corruption in those states? 1. 2, the Congress worked hard and immediately to try to do what it could, given in the aftermath of the opinion, by drafting a thing called disclose. You may be aware that it was narrowly defeated in a why is worth unpacking partisan vote. That was insufficient to overcome a Republican filibuster. The ACLU was very opposed to disclose, by the way, and concerned about constitutional infirmities of it because the opinion seems to endorse part of the opinion that Dave didn't spend as much time on. Disclosure, that's better, right? We voters, as long as we know what's going on, we'll make good choices. But maximum disclosure can invade privacy. So a prediction I have is a lot of the work, the constitutional analysis and thinking is going to go to the limits, the constitutional limits on disclosure. And also the practical analysis of whether, if we know more, do we really vote better? In fact. Technological intervention. Zephyr Teachout has written a great article in which she talks about how a lot of this is really quaint. That in fact there are all kinds of ways to reach potential voters and influence elections that have nothing to do with traditional forms of electioneering. Another thing that the New York Times and other major publications have talked about is anonymous giving that can go through. This is permitted and was before. You can go through, since corporations don't really like to be seen as weighing in partisan elections. It's not good for business often, but they can donate to the Chamber of Commerce, for example. Some of you may have seen that story. And so, there's all kinds of ways in which the how to influence elections apparatus was already in place. And after the opinion, it's unclear to me whether the elimination of these restrictions is going to make as big a difference as opponents of the case fear. I don't know the answer to it. I do think where there's a will, there's a way. When it comes to influencing elections, there's a lot of will, and there's a lot of money, and there's a way. Here in Arizona, it may immediately have an impact. There's a case pending. I don't think they've accepted cert yet. That will look at the question of post-Citizens United. Is it permissible to have clean elections laws that demand that you match money? If I go clean election and you spend individually, this was an issue when John Munger was a candidate, and he has been quite eloquent in talking about his objections to this. I spend my own money. Is it constitutionally permissible, or does it violate this equalizing principle for the state to give money? As I spend, my opponent gets the money. It was an issue in the gubernatorial race with Governor Napolitano. And I think immediately Citizens United, the logic of it, suggests that Arizona clean elections is in trouble. Bigger aftermath, First Amendment theory implications. I think it's really easy to, I think Kennedy is dewy-eyed in this opinion. Voter perspicuity, the Odysseus-like ability of a legislator to strap him or herself to the mast and slide past the sirens of big bucks and go, oh, I don't mind that you're pro-blah. I think that no American really takes that seriously, and I think that's a problem for the court. And I think it was unnecessary. The First Amendment itself has, over the years, evolved into something that's a pragmatic, it isn't an unbridled, romanticized embrace of a free marketplace of ideas. It recognizes marketplace failures. It recognizes distortion in other areas of the law. It recognizes the danger of corruption. And so I think that Citizens United is vulnerable because in defense of, they reached out, and then in defense of his conclusions, Kennedy went too far. It's one bromide after another. It's one statement after another that if it came, I don't want to sound disrespectful, you would want to, if someone gave you a paper with that, so you need to qualify it. There needs to be some nuance here, and I think that this will push people in the case more, in fact, to not the historical aspect of the Scalia opinion in the case so much, where he refutes Stevens on those grounds. But if you look at Scalia's opinion, he's much more careful about the claims that he's making in here. And I think court credibility is undermined when they go too far. They went way too far. Contrast that when they took the Voting Rights Act case. Contrast that, like you say, what they did in the Peekaboo case. Contrast in a lot of their cases, and I think that they just simply, I guess they just wanted to end it. But I don't think it's going to end this discussion at all. Last but not least, you saw it on display. Back to the Elena Kagan hearings. You couldn't tell, I couldn't tell, and I watched every minute of it at my desk. It was within my job description, Dean. Junkie. You couldn't tell when the senator was asking the question whether it was a D or an R if you went like this and you don't memorize their voices until the last word. And if the last word was Citizens United, it was a Democrat. If, and this was weird, the last word was Thurgood Marshall, that is what happened. It was a Republican. But they were making identical claims about an activist court. And Citizens United, it suggests that Bush against Gore is no longer the court's bad hair day. It looked partisan. And the American people don't drill into the analysis in a careful way. Very few people can claim to be election law specialists. I don't, any more than you can claim to be an immigration law specialist. But God, people have opinions. And on this one, they feel very strongly because of the practical point that Dave made earlier. We smell a rat. We smell the big rat. Money corrupts. Big money corrupts. It's nonsensical to tell us otherwise. And he didn't write an opinion that really addresses that intuition. And I think that was one of the many failures of the majority of the Kennedy opinion case.
Let's go to the election law expert first, and then we can go back to Ms. Mahoney.
For those of you who have looked at this opinion, you will probably agree that the most compelling statement in all these opinions is at the beginning of Justice Stevens' decision where he says, "I regret the length of what follows." Now, that said, I agree with Toni that there is a disappointing quality of simplistic generalizations in Justice Kennedy's opinion. At a high level of abstraction about a pay-on to the open marketplace of expression that I fear the theory, the First Amendment theory has gotten beyond or has failed to capture the complexity of events and behavior and conduct in this area. So this very simplified notion of more speech is better no matter what, simply doesn't reflect the reality of politics, how public officials operate, how the public operates. Now, I'm not saying I have the answer to these difficult questions, but there is more to it than simply invoking these aphorisms one after another. The limitation that judges have to decide questions, and the law is a shared enterprise, and therefore we use language to communicate them as a shared enterprise. But there are limitations in the ability of language to capture the complexity of events and motivations, and I fear this is an area where that is particularly true about campaign expenditures. I personally think this language about corruption is an unfortunate word because the reality is politicians act out of fear and gratitude, and both, maybe more fear than gratitude. You don't need corruption for massive collections of money that are, especially now under this case with business corporations, that can be aggregated with legal privileges that were intended for purposes of commerce, of collecting capital and serving the economy, now to be sidetracked for political expenditures where the direct players in the political process are working their fingers to the bone trying to raise money, and large moneyed corporations now going to do these independent expenditures. So I am not going to venture to say a whole lot more other than that I find the analysis to be very unsatisfying, and that the practical reality of how politics works and government works and how people vote and how politicians work simply is not captured by Justice Kennedy's opinion.
I find the reaction to Citizens United baffling. And the reason I find it baffling is I understand that there are people who like campaign finance reform, may want to, cabin political expenditures by corporations or whatever. But what the court did was do a an analysis of the First Amendment that led them to conclude that this provision of this statute was unconstitutional, and so they struck it down, which is exactly what they did in another First Amendment case involving a congressional ban on crush videos. I don't know if any of you are familiar with that case. There was no uproar about that the Supreme Court said it violates First Amendment principles, and ergo, it has to be struck down. But because there are so many people who are advocates of campaign finance reform, suddenly the court must have gone rogue because they struck it down. And I think actually, if you look at the decision, you may disagree with the reasoning, but it is reasoned. And let's talk about what this statute actually does. This isn't just campaign finance in a vacuum. This is an actual statute that, as the court explains, that it makes it a crime for the Sierra Club, a corporation, to publish a book opposing a candidate 30 days before an election based upon their lousy environmental record. That's a crime. And the court said, we can't have statutes like this. Corporations have First Amendment rights. And Buckley held that you can't say that someone doesn't have a First Amendment right to spend money and speak, have political speech based upon their wealth. And so some individual who certainly has the capacity to influence President Obama, who has $1 billion in wealth and gives endless amounts of money to run ads in his favor, is allowed to speak. Why not a corporation then? And corporations, by the way, don't just support Republicans. Corporations gave major amounts of money to the Democratic Party during the Obama election. They assess their interests based on who they think is going to have power. And a lot of corporations don't even like to give money because they find that it puts them in an odd position with respect to consumers. So I think that probably, at least in my mind, and this idea about the court overreaching by deciding the issue of whether to overrule the prior precedent, they actually looked at the narrower grounds and found that they didn't resolve the case. It wasn't as if they just blew by them and didn't look at them. They analyzed them. And they concluded that the only way to resolve the case was to decide whether or not the prior precedents, Austin from 1990 and McDonald, should be overruled. And they needed to decide that in order to decide this case. So again, reasonable people can disagree with the analysis, but the idea that they did something startling, I'm just kind of taken aback by it. And I think it's just because politicians, this is their bailiwick, this is what they care about, and so they decided to make a big issue about it. Judge Wade?
Once again, I need to revise and extend my remarks. I was intentionally trying to be stimulating and provocative when I said politicians act out of fear and gratitude. But of course, one must also recognize the broader fact that public officials act out of their concern for public interest. And I don't want my statement to be taken without recognition of that. But it fits together because even with their views of public interest, they all have to have that fear about the influence of huge amounts of independent expenditures. I'll give an example for people here in Arizona that we just had a primary election, and up in my county, in Maricopa County, the Sheriff Arpaio, spent $750,000 of his own campaign money basically attacking somebody in the Republican primary for county attorney. Now that walks, talks, and quacks like independent expenditures, and I'm not going to offer any comment about whether that does or does not violate Arizona expenditure laws. I don't know. But there's no question that had a significant influence on that election. So that was not corporate money. That was campaign money that the sheriff had raised legitimately. And again, I make no comment on whether he did anything inappropriate, but it's an example of the effect of independent expenditures can have. Oh, and I did have another comment about Maureen's comment about whether the court overreached. There has been a lot of comment to that effect, and it looks that way. But on the other hand, you read the opinion, there are areas of law that once they get decided by a court of last resort are extremely difficult to revisit. It can be very difficult to have a case that would give them a chance. So I think one must temper the view of what they did here with that perspective that this is a very important area. If you think their decision is right, or if you don't, it's still an important area of First Amendment law, and it could be really difficult. Decades could go by before an appropriate test case could come. So one has to give them some leeway in that regard.
I think it's really important. They were very worried about the fact pattern that I described of a corporate entity publishing a book, like the Sierra Club, publishing a book that opposes a candidate based upon their environmental record or their gun record, if it's the NRA or whatever. And when the United States was asked those questions at oral argument, they couldn't say that wasn't a problem.
And that's why I wish you'd written the opinion instead of Justice Kennedy, because I think if you read the opinion, everything that Maureen is saying is true, and it is that part of the opinion that Professor Sherry is pointing to as saying, look, hold the phone. People went hysterical without reading the opinion, but it happens all the time, and it just doesn't happen in cases like this, and it happens with respect to the Establishment Clause. Woo, the sky's falling, in a term where they upheld one display and struck down another. Or other websites where they point to results selectively in order to mobilize a base into thinking that the court should be taken out and killed. My point is that, I mean, I can tell you right now, Justice Stevens raised the point about whether foreign national spending now is potentially unconstitutional. Restrictions on foreign national spending in American elections are potentially unconstitutional. I think there is a surprisingly strong argument, post-Citizens United, that it is. And it has a lot to do with how Kennedy wrote the opinion. It would be much harder to make that claim by looking at the concurring opinion by Justice Scalia. And so I think there was literally a kind of recklessness. He got carried away with his enthusiasm. And I think I wouldn't point to U.S. versus Stevens, the crushed video case, but the performance of the Chief and Holder versus Humanitarian Law Project, in which they were much more careful in justifying a restriction on speech by an American citizen that supported or was done in coordination with a foreign terrorist organization, in which I think they showed some mature recognition of the tension. And in this case, there are First Amendment values on both sides. And I think he just did a very unsatisfying job of explaining to those of us who think that corruption matters why that should not be given more weight. That example and that answer in oral arguments, it was all over but the shouting once that answer came out. So I think you're exactly right about the law and the problems with the law, but then you might do an overdraft. There's other ways in which I think they could have achieved the same result and educated the American people instead of simply enraging them with an opinion to the extent it was read or understood as sounding pretty cartoonish almost about something as sophisticated as the First Amendment. And we have implications right now with the mosque and on other problems the day after. Breyer's taking a hit this morning in the news because he said that he thought that the First Amendment may not protect the burning of the Quran. Now, it's taken out of context.
Did he actually say that, or was that just an implication?
No, it was taken out of context. But it's because people don't have much patience for a more subtle conversation about the limits of the First Amendment and the ways in which it's a balance between the things that we want to hear and the cost of hearing it.
Professor Marcus?
Yeah, I mean, I didn't go hysterical until I read the opinion, so I was just mildly irritated.
You were born hysterical.
You hired me, so. On one level, I am very sympathetic to Ms. Mahoney's question: why were people so up in arms about this? I don't know what the exact number is, but it's like $1.2 billion was spent on the last presidential election. At what point is the tsunami of money so significant that Exxon spending some more will really make a difference? I don't know. I mean, it's an empirical question. California allows these kind of expenditures, and tends to be the case that few corporations actually make independent expenditures. They find lobbying a much more effective way to influence voting patterns. But that's why I started by saying it's after the opinion that I went hysterical, because not to add to what others have said already, but yeah, of course the court addressed the avoidance issue and said, we can't but decide the facial constitutionality of the McCain-Feingold Act. And of course the court went through the requisite stare decisis analysis to explain why it could legitimately jettison McDonald and Austin. It's just the paucity of reasoning in each of those is so poor. I don't want to gild the lily, but just to read a little bit of Justice Kennedy's analysis of stare decisis, he says, Austin is undermined by experience since its announcement. Why? Our nation's speech dynamic is changing, and informative voices should not have to circumvent onerous restrictions to exercise their First Amendment rights. Speakers have become adept at presenting citizens with sound bites, talking points, and scripted messages that dominate the 24-hour news cycle. I could go on, but it's that vapid discussion that I find deeply unconvincing and disappointing when it comes to something as significant as getting rid of a case decided only 8 years earlier. It's without a doubt. I mean, it's obvious because I think O'Connor wrote Austin, right? So O'Connor wrote Austin. O'Connor's replaced by Alito. It's clear where this case comes from. O'Connor has, since stepping down from the court, made integrity in judicial elections one of her signal causes. So the atmospherics of this case are so overwhelmingly ideological that it just sits very poorly, I think. And for that reason, I don't find on a different level the reaction particularly baffling.
Ms. Mahoney, you made the point earlier that it was not the majority of the court that was sort of in line with public opinion, but Justice Kennedy. I'm not maybe misquoting you, but just sort of that he's...
In some areas of the law, he views emerging public consensus as relevant to his constitutional analysis.
Right.
Yeah.
Do you think that is at play here with his decision? And do you think, based on your experience, both arguing before the court and as a law clerk, the fact that he wrote the majority opinion, what do you think is sort of at play here?
Yeah, I think probably public consensus is less relevant to him in the First Amendment area than it is in definitions of due process, Eighth Amendment, jurisprudence, those sorts of areas. Mm-hmm. And I haven't tracked it carefully enough to be sure, but I certainly in the Citizens United area, if he thought public opinion was highly relevant to the contours of the First Amendment doctrine, he might not have been able to come out as he did, because I think that people have probably correctly represented that there is substantial public opinion in favor of regulation of corporate expenditures.
Mm-hmm. So why do you think it was his opinion to write?
Well, I think he often writes the First Amendment opinions because it's an area of the law I think that he cares very deeply about, and usually he's going to be the swing, and so I think he's given the opportunity to write some of those decisions.
But clearly he was going to come down with the majority. Yeah, it seems, regardless of who wrote the opinion.
Yeah, I think that's right. Although the fact that Roberts, wrote with Alito on stare decisis separately might be telling for some future cases as well, because I think that they didn't really embrace the Casey kind of analysis in the same way that Justice Kennedy. I mean, they don't. They join Justice Kennedy's opinion, but I think they kind of make a real point of saying that they think that when you have to reinvent the rationale for a prior precedent, it's really no longer deserving of respect, and that was what was going on here.
Anyone else? Final word? Yeah. We have about 20 minutes left to take questions from the audience about any of the cases. Yes.
Specifically about this case, what I'm wondering, and in this discussion about the public outcry as a result, and maybe this is more of a sociological question than than a constitutional jurisprudential question. But did this case and the public outcry that resulted create a scenario in which Rupert Murdoch could donate $1 million to the Republican Party with relatively little outcry outside of maybe the far fringes of the left wing? They've now agreed that they'll make a public service announcement admitting the fact that people who own Fox News are going to have just donated $1 million to the Republican Party, but they're only going to show the announcement one time ever for about 15 seconds, and that's it. But would that kind of activity have been possible from a free market perspective, absent the kind of outcry that comes in the culture surrounding a case like this?
I'm not sure I understood the question probably, but the statute that was struck down actually allowed media corporations to spend all the money they wanted it's supporting or opposing candidates, which is one of the things that Justice Kennedy's opinion says, give me a break. Why is it that media companies get to exercise their free speech rights, but other companies don't, showing the fallacy of the logic of the legislation, basically. So, and certainly as an individual, Rupert Murdoch can spend as much money as he wants under Buckley.
Because he's an anchor baby. I'm sorry, it's late. Because he became a U.S. citizen. And he did so in order to avoid certain restrictions on foreign ownership of media corporations. That too, I think now, it's a good question whether some of those laws are overbroad statements given First Amendment interests, but more on that another Supreme Court review, because I think it's coming. Okay.
Yes.
You know, I don't know whether I agree or disagree with Judge Wade in terms of what his comment applied to. We talked about simplistic approaches or a lack of understanding of how the marketplace of ideas works out. And I think part of the problem in the case is that the Congress manifested that simplicity. And one of the reasons I do is what Maureen just said, and that is that they created an exception for media corporations, which immediately raises the issue of content-based distinction. Another one is that, as the opinion mentions, a very large majority of corporations are not the kind of corporations that the dissent spend a lot of time talking about. My friend, who has a little corporation to buy and sell trucks, could not have made a direct expenditure or a run. And thirdly, as has also been referred to, there are people who have massive amounts of wealth, or Soros, Murdoch, you can name your favorite villain, who are not doing it in a corporate format. So it seems to me that the case is totally understandable in the sense that it was a blunt instrument the statute was, and it's a very important First Amendment principle, as Maureen talked about with the book that could be published. And when you think about it, there were very, very important First Amendment principles. And you can talk about whether it was a great majority opinion or whether it was a great dissent, and we can each pick our favorite one to attack. But when you take the bluntness of the statute and the simplicity of the principle, it seems to me that this is not a remarkable case.
Comment? Thank you. Yes.
There was a media exception to that statute. Is that? I guess I don't understand the distinction there in terms of the multinational quality of the media conglomerates. General Electric, Time Warner. I mean, these entities are so vast in their holdings that how do you define a media entity at this point?
Two parts to your question. One is, how do you define a media entity? And I think Kennedy does have the better of the argument for the reasons Michael's pointing out. There is no, while we have a right to press, there's no constitutional significance to an organized media right to speak and a pamphleteer. And so once they carved out that exception for media corporations, they produce a problem of analysis. The second question you're raising is a tougher one. Who is a foreign national? And what do we do with multinational corporations, and how do we define individuals. It's not just, if you are a permanent resident, non-citizen, you are exempted from the federal statutory definition of a foreign national who cannot engage in certain election campaign expenditures. In other words, the law is actually pretty darn generous with respect to foreign nationals if they have a presence here. And what some of the corporations, their hook is that they have subsidiaries, American subsidiaries, and that domesticates them for purposes of the statute, makes them American citizens. Then the only restriction on them is not about whether they're foreign, it's whether they're a corporation. In this case, Citizens United deals with whether the ways in which corporations and unions are treated differently with respect to independent expenditures was constitutionally sustainable. So if they're entirely foreign and they don't have an American subsidiary, in that case then they would be subject to substantial restrictions on what they can do because they're foreign. Does that make sense?
Well, it does, except it's so easy to create a U.S. subsidiary. I mean,
That's why I wasn't being entirely facetious when I said a much bigger issue in terms of effect on American daily life, it strikes me, is the ease with which a foreign corporation can become a citizen for purposes of having a substantial potential effect on American elections. That strikes me as more important than, not to get into another controversial topic, but individuals coming over the border and having children and those children becoming American citizens because of the citizenship clause of the 14th Amendment. The difference is one's done it legally, the argument would be, and the other isn't, but not true. The child, by constitutional perforce, legally becomes a U.S. citizen because of being born here.
an ancillary question to that. I noticed that this entity was a nonprofit corporation. Is the assumption that it was not only a nonprofit corporation, but it was also a tax-exempt corporation?
It was nonprofit and well, Dave was doing the facts, but it was nonprofit. I think the concern was it was receiving a small number of donations from corporations, right?
Nonprofit is usually a state-defined term, whereas tax-exempt is a federal-defined term, tax-exempt under 501c3. And the reason why I bring that up is 501c3 tax-exempt organizations cannot, under the Internal Revenue Code, policy.
There's a good point that he's making that applies, and Justice Kennedy deals with it somewhat toward the end of the opinion. One might, the theory of the corporation problem, and her saying, look, a lot of corporations aren't going to do this anyway. Some corporations aren't going to do it because they're prohibited from doing it. And what he gets to that point in the opinion, he says, let's leave that to corporate governance rules. Let's leave that to, the definition of what are permissible aims. It's like those of you who are members of the State Bar know that the Board of Governors can only do certain things with your dues because it is deemed to be outside of their jurisdiction to use your dues money to promote certain political causes. Nothing about this opinion, maybe I haven't thought it through, undermines the claim that government may have a legitimate interest in restricting the political activity of federal workers, of corporations in some contexts, or under shareholder rights. I'm looking at Elliot because we need a corporate specialist to talk about what those existing regulations look like. Does that make sense? Back? You might be right as a matter of not-for-profit status.
We have somebody back here.
I think that a lot of the blame that people are discussing now seems to be centered on Justice Kennedy's opinion. But to what extent did the Deputy SG's discourse with the Chief Justice, when there was a question posed about would this allow for banning a book, to what extent did that kind of pin Kennedy and even some of the liberal justices into having a very tough time deciding for the FEC from a lawyering perspective, and then also from a constitutional theory perspective? Is there any way in First Amendment jurisprudence to differentiate between a book and a movie that's massively advertised on pay-per-view television?
Not that I know of, but you're going.
I think that he answered honestly, You know, he's an officer of the court who was asked the question, and he gave an answer to the best of his ability of what he thought the statute meant, and it's the strongest argument in favor of what Maureen's arguing. Was there another way they could have handled the case? And one way they might have handled the case is to say that the law wasn't actually meant to apply to particular or direct TV videos of this sort. I mean, there were some narrow possibilities that I think weren't frivolous that they could have said to distinguish this particular entity wanting to engage in electioneering. But the bigger point that you're raising, I agree with her, I don't know a way to make that distinction. Okay? Elliot?
Yeah, I guess what strikes me about this whole discussion is that one of the premises of it was in Buckley against Vallejo, which established that expenditures are the equivalent of speech, and therefore expenditures cannot be limited. I think, Toni, your recent comment about foreign corporations and their potential impact on our political process has implicit in it the belief, which I share, that expenditures are not merely the expression of an idea. I don't think anybody would be troubled allowing any individual or even any corporation to express an idea. It's the ability to spend thousands and perhaps millions of dollars broadcasting that idea, blasting it into the public's consciousness, that have to have a distorting effect on our political process. But it seems to me this entire dialogue starts from the premise that we must accept that holding of Buckley, and it seems to me that's the fundamental flaw in the law in this area.
I remember when Buckley versus Vallejo was decided, and I remember having that similar thought. The reality is it does have an expressive quality, but it's more than that, and that's part of what I was thinking when I said earlier about the events and the behavior here is more complex than this linguistic equivalence of speech with expenditures allows.
Just think of the difference between my ability to go to Congresswoman Gifford's office every single day and tell her what I think, and tell her what I think, and tell her what I think. Nothing restricts it. But I can't give her or another candidate above a certain amount. I mean, it blinks reality and other areas of law not to see expending money as different. And I think the difference is she has to listen, and I may give her ideas that she can use herself, but if I give her money, I'm giving her something fungible that enables her to express herself in a more powerful way. And if I give her a lot of it, I think that she's probably going to listen to me a little more closely than if I just go to her office every day. And, you know, it just seems so obvious.
But this isn't about giving money directly to the candidate. It's not about political contributions. It's about a corporate entity that decides that they want to run an ad about why Obamacare is really a bad thing. Let's imagine you're a healthcare company, and you in fact know that it's going to destroy your business. And there are candidates running, some who are in favor of repealing it and others who aren't, and you want to run an ad explaining why the voters should support a particular candidate because of their views about health care. And that seems to me to be core political speech under anyone's definition. Now, you might decide that the First Amendment's got enough play in the joints that they're going to allow corporations to be treated differently, but it certainly is core and pure political speech that we're talking about.
Right, but no one disagrees that it's core political speech. But and the court is embracing a particular theory about what we do about that, but it's stockpiling assumptions, money and speech, corporations as persons, corruption is only direct quid pro quo, and after a certain point you have to stop and say, we lost track of things. I know we have to close, but for a long time, Owen Fiss, among others, have said, this notion of a marketplace of ideas, we embrace it, we talk about it, but we've always thought that the best response to bad ideas is counter-speech. And if that's the premise, if that's the experiment, if that is the empirical assumption on which this is based, then you have to pay attention to the capacity for counter-speech. That's what I mean, there are First Amendment values on both sides. And so Fisk said, and this was true when we were first developing television, you have zero-sum scenarios and broadcast media and concentrations of power, vehicles for expression. Good people in good faith, card-carrying First Amendment enthusiasts thought maybe to maximize First Amendment values, we might have to do something ironic. We might have to limit it in order to assure that all the ideas get out there and we have some capacity to reason through them. And that has been rejected at almost every turn, except maybe with capture problems like broadcast media. But it still, I think, responds to some of the reality that disturb people in some contexts where they feel they watch TV and there are like ideas there but none of theirs. It's like the Russian visitor years ago who said, the thing about American newspapers that's interesting, you all talk about your freedom of speech, but I read your newspapers, how come they all say the same thing? And you kind of go, that was when I was young and civic ideal, dewy-eyed myself. And if that happens, if you don't think that's a First Amendment catastrophe, whether it's happened, I think we catastrophize without really analyzing. Is that really what's happened? Are we really so stupid that when we watch these ads, we don't suspect that there's, certain pockets that are paying for it?
But that's why, the disclosure laws are important.
Yeah. And that's what the next argument, I think, is are the disclosure laws constitutional? And that the other case we didn't discuss, the Doe case, and I think we've got some opponents of disclosure laws on the court.
And just one more doctrinal point, and that is that people have to remember that you can make all sorts of good policy arguments, one side or the other or whatever, but this is supposed to be strict scrutiny.
Yeah.
That's the problem that a lot of the campaign finance reform advocates have, which is that strict scrutiny means you don't get to just say, well, there's some reasonable reason why this statute ought to, work.
I agree.
It's got to be more than that.
Republican Party versus White, Scalia, if you want to know how strict scrutiny ought to be done, look at how Justice Scalia looks at strict scrutiny for the announce clause of judges running for office. I think it's a fabulous example of doing it with all the teeth in place. But that same strict scrutiny should have applied in Holder versus Humanitarian Law Project, and I don't think even within a given term they're necessarily bearing their teeth as strenuously in every single case. And if they did, then okay, great. But I don't think as a practical matter they always do.
Okay. Now we can all go outside and bare our teeth. There's a reception in the lobby. Thank you very much.